Please be seated. Good morning, everyone.
Morning.
Welcome to the May docket of the Kansas Court of Appeals, sitting here in Johnson County. I am Thomas Malone. To my right is Judge Gordon Atchison. To my left is retired Judge Michael Boozer, who's especially assigned to be serving on our court today. We are the panel for the cases today. I'll call your cases in the order of the published docket. When your case is called, please come forward. I see the first attorneys are already here. We'll get your appearances and then proceed with the case. As most of you probably know, we have read your briefs. We're familiar with the facts of your case and what the issues are. So you might keep that in mind as you make your argument. As the presiding judge, I'll be the timekeeper. We have a clock up here that keeps time. Everybody is normally given 15 minutes per side for your argument, unless it's specially designated on the docket, which I think our first case is scheduled for 20 minutes. When you begin your hearing argument, the appellant's attorney should let us know at the beginning of your argument if you wish to reserve any of your time for rebuttal. If there's more than one attorney per side, you need to let us know in advance how you wish to divide your time. After the arguments, your case will be taken under advice. It'll be deemed submitted for decision and taken under advisement. And we will get a written opinion out to you and your clients just as soon as we possibly can. So with that explanation, I'll go ahead and call the first case on the docket. It is from here in Johnson County. It's number 128-510, Sierra Club and Boat Solar versus KCC and Effigy. So we'll start off with, who do we have here for the appellant?
Your Honor, for the appellant, Will Wolford will be arguing the case. Trevor Wolford is with me at council table, and Evergy's in-house counsel, Kathy Dingus, is in the gallery. I'd like to reserve 5 minutes for rebuttal, if that pleases the court.
That will be granted. And who do we have here for the appellee?
Good morning, David Bender for the appellees and cross appellants, Sierra Club and Vote Solar.
Okay. All right. Mr. Wolford, whenever you're ready.
Yes, may it please the court. Panel, this is an appeal of the district court's decision overturning the KCC's approval of a settlement order regarding tariff revisions to address consequences and impacts of wholesale demand response activities on Evergy's state-regulated electric distribution system. So the approval of the tariff at the KCC level is a quasi-legislative function. It is a rulemaking which is entitled to the utmost deference from the judicial branch, the facts found in that docket. This is a case that concerns wholesale demand response aggregation and rules related to it, which sits somewhat at the intersection of federal and state jurisdiction. But it encompasses principles of cooperative federalism, where states have their own sphere of regulation and the federal government has its own sphere. Evergy's position is that the district court's holding and the appellee's arguments really urge a version of preemption and federalism that would have the federal government essentially muscle out the state's valid and important regulation of impacts from DR aggregation and those impacts on the local distribution grid. This is a case where there was facts presented to the KCC through testimony where Sierra Club, Vote Solar had the opportunity to ask for an evidentiary hearing and did not do that. This is a case with a settlement with near unanimous approval across a broad range of participants, including Voltus, who is the only DR aggregator operating in Kansas. We believe the overturning of the KCC's approval of the order was an error for at least 3 reasons, which I will get into now. First, Your Honors, the issue of standing is a threshold issue that has to be addressed to make sure that there is subject matter jurisdiction and a justiciable claim. For an association like the appellees to have standing, there needs to be members that have a cognizable injury with a causal connection between that injury and the KCC order. It has to be an injury in fact and personally suffered, imminent, and not speculative. What has been presented by the appellees in this case are declarations to attempt to show standing that fall well short of that mark, Your Honors. The injuries that are proposed are both speculative and or generalized grievances, and they do not rise to the level to provide standing to the organization to challenge the KCC's order in court. Those injuries that are proposed in the declarations, why they are speculative, why they are generalized, is this. They are provided on behalf of residential customers of Evergy, generally. Those residential customers, Voltus is the only DR aggregator operating in Kansas. It does not operate a residential DR aggregator service. It does not have a program to provide DR aggregation for residential customers. There is no evidence to show that there is an imminent time when that would arise.
Let me
yes.
ask a question about
yes.
Actually, this is your reply brief. You're making this point, and on page 13, you say, currently there is no ARC that aggregates residential customer loads in Kansas, nor is one imminently expected to start operating in the state.
Yes, Your Honor.
I kind of consider that a fact statement, even though it's not in the facts section. But my question is, do you have a record site that tells us that? What can we turn to in the record that establishes?
Yeah, I don't know. There is some record citation that identifies what Voltus does as a DR aggregator now. I know that is at record 3, 124 and record 4, 168, and it identifies that Voltus only does commercial and industrial customers and only provides DR aggregation for those customers now. I think the record is devoid of any suggestion that Voltus or any aggregator is on the precipice of providing that service for retail customers in the state. Yes.
Let me ask you this question.
Mm-hmm.
I've got a couple of forms here.
Uh-huh.
Maybe I'm not even sure what these forms are, but I think this form here is for residential customers to participate in demand response through an ARC. And this form here is for residential customers to participate in demand response directly without an ARC. Why do we even have these forms if residential customers are never going to be able to participate in demand response, and so they have no standing? Why do we even have these forms?
I think the forms are created in the case that does happen in the future. There is no evidence in the record, and there is no instance showing that an ARC, a DR aggregator, actually is functioning toward providing DR aggregator services for residential customers. However, I think Evergy is preparing for that eventuality at some point. And there is also a difference too between DR aggregation in the wholesale market and the retail market. And so there there may be some forms that allow residential DR aggregation in the retail market, but not the wholesale market. But that being said, I think Evergy's approach is we prepare for that eventuality if it occurs, but it is still an eventuality that is not on the precipice based upon what we've seen and what's in the record here in this case, that there is no provider to provide wholesale DR aggregation for retail customers, at least in the near future. The issue also goes to, I wanted to mention in addition, the issue of increased power costs that was raised as a possible harm is both counterfactual and is a generalized grievance. It's counterfactual because the KCC found, based upon the evidence, that it would not, there would not, that the changes to the tariffs would not increase power costs. If anything, it would place downward pressure on those costs, and those findings of fact have to be respected here. And it's a generalized grievance because it's essentially, if it increases costs across the board, it's not a specific injury to that specific retail customer. It affects everyone the same way. So our position is that there is no standing on behalf of the organization. We also, the second issue and error that Evergy cites is that the district court went well beyond the scope of the appropriate scope of review. It went into issues that were not stipulated by the parties. It made findings sua sponte that the KCC had abdicated its role to regulate these activities, which is not true. It's not supported within the docket or within the evidence at all. And Your Honor, I think our brief handles those pretty well, so I'm going to move on pretty quickly. But the point I'd like to make too is I think Applebee's really didn't support the district court's rationale or holding on this idea that the KCC had abdicated its role to regulate here. I don't think there's much more that needs to be said. I think the district court went well outside the bounds of its really appropriate review when it made those findings. The final issue that I'd like to address relates to federal preemption and federalism, which I think is really the meat of the argument here. And
launch into that. Let me
yes.
ask a question. It seemed like the district court was very concerned about Evergy having the right to disqualify or give consent to or withdraw consent to participants in the aggregate market. Are there discernible and definable standards by which Evergy exercises that consent authority?
Yes, I believe and I don't have the record site, but I believe that the KCC stated that it is basically a ministerial process of going over to make sure that all the boxes are checked, and if they are, that it gets approved as a matter of fact. The standard, I believe, is that it will not, that approval or moving through the process will not be unreasonably withheld, but it was characterized as essentially a ministerial task for approval.
The forms are submitted and the boxes are checked, then they're in.
They're in. Yeah, it's not a question of, well, do we like this? Do we like this group? Do we not like this group? No. If they check the boxes, go through the process and fill out the forms, they're able to participate.
They have to participate through an approved
an approved ARC, correct? Yes, and that's part of the process and part of the the tariff revisions relate to that specifically.
What is the purpose in having these forms? I mean, that's the new part of this. How does that enhance sort of the efficiency and the safety that Evergy is claiming?
Yeah, that is the technicality of that is really sort of above my understanding and pay grade, but there is evidence.
We're not understanding it and asking the question.
Yeah, the evidence that was submitted was that this regulate or these forms and this information allows Evergy a look into that part of the market and some controls to be able to understand and make sure that demand responses bid in are accurate and the registrations are accurate. It allows them to prepare for fluctuations related to large demand response activity on the grid, which may change not only where power needs to go, but excuse me, power quality issues as well. Not being an engineer, I don't know the specifics of why that is, but that's the evidence, and it is unchallenged, Your Honor. It's not only unchallenged in that Evergy submitted that evidence, that KCC in its findings found that those are valid reasons to have these tariff provisions and have this look into the wholesale DR aggregation activity.
When Evergy submitted this tariff, there were a number of interveners, including Curb.
Yes.
And they later had settlement negotiations, and then you had this partial settlement.
Yes.
I'm curious, what were the provisions that Evergy changed that apparently encouraged Curb and other interveners to not only give up their objections, but they actually filed?
Yeah, I wish I had a good answer for that, Your Honor. I don't specifically know what that is. I can see if maybe I can find that answer and update you on rebuttal. But I don't know specifically what those are. At any rate, very quickly, the first off, the threshold issue of that relates to the federal preemption. There has to be a federal anchor. Federal jurisdiction really is over the ARC's transactions with the RTOs and what is being regulated by Evergy and the KCC here is the customer's relationship with Evergy. That's a common area for regulation by state regulators. It does not create a conflict with any federal law. It does not create a barrier to the enforcement of any federal law. It was found not to create a barrier to any participation in DR aggregation in the future. It actually really does complement, I think, federal efforts in the DR aggregation area. And it is consistent with the precepts and principles of cooperative federalism that underlie this program that straddles the line, Your Honor. There are a lot of items to go through in the federalism and preemption issues. I see my time has run out. I think we handled them very well in our briefs. If there are any questions you have for me right now, I'd be happy to answer them. I do note too that there was an issue of ultra virus cross appeal issue raised by the appellees, stating that the KCC regulated outside of its legal authority. And again, I think we handled that well on the briefs. This is well within traditional regulation authority of the KCC. It is consistent with the KCC's regulation of impacts on the retail grid from various types of programs, and it's consistent with traditional tariff regulation and findings in the court. I'd be happy to answer any questions. Otherwise, I'd reserve the rest of my time for rebuttal.
this might be an overgeneralization, but would you say that Judge Vano found that he found that there was no field preemption,
I agree.
but he struck the tariff down based upon some form of conflict preemption. That's at least a correct statement.
I would agree. He did not find field preemption applied. He found, which we agree, field preemption does not apply. He found that there was some kind of obstacle preemption, which we vehemently disagree with. We think this is complementary to federal power, as we've set forth well in our briefs.
Thank you.
Yes. Any other questions? I'd be happy to answer.
Apparently.
Thank you, Your Honors. I'll reserve the rest of my time. Thank you.
Morning. May it please the court, David Bender for the appellees, cross appellants, Sierra Club and Vote Solar. I'd like to address three topics with the court this morning. First, Sierra Club and Vote Solar have standing. Their members are interested and would participate in demand response aggregation in wholesale markets, but for the burdens imposed by the tariffs challenged here. Second, the district court correctly found the tariffs were preempted by the Federal Power Act. My read of the district court's decision may be a little different than my friend from Evergy. I see findings of both field and conflict preemption in the decision. It goes back and forth. It cites field preemption cases and makes findings consistent with field preemption, including the court's finding that the KCC overstepped its authority by imposing state requirements on a federal market participation. That is a field preemption finding. The court also found conflict preemption, that the regulatory burdens imposed by the tariffs here are contrary to policies in federal law that the Federal Energy Regulatory Commission sought to promote, namely a streamlined and quick process for registration, and for specifically rejected comments by the KCC in the federal rulemaking proceeding, in which the KCC asked for more state authority to essentially do what it did here. And FERC said no. And then the KCC and Evergy went ahead and did it at the state level anyways. And third, even if the KCC's tariffs here were not preempted by federal law, they still exceed the KCC's state statutory authority. For the KCC to approve any tariffs, it needs to meet at least two criteria. First, it has to be able to point to some statutory authority, giving it substantive authority to regulate the activities that are the subject of the tariffs. Second, it has to ensure that the tariffs do not conflict with or regulate within a field that's the sole domain of the federal government. The tariffs in this case fail on both counts. So they exceed the KCC's statutory authority. I'd note that in its order approving the tariffs, in response to petitioners, Sierra Club and Vote Solar's opposition to it, the commission identified three purported bases for why it can impose regulation on the act of registering in a federal wholesale market. It pointed to what it called its inherent authority, because this touches on electricity generally. Second, it points to the auxiliary clause in statute 66-101, giving it necessary and proper authority to regulate. And it pointed to the Supreme Court's decision in Denisco, if I'm pronouncing that correctly. On appeal, the commission does not appear and does not submit briefs. Evergy defends the statutory authority, but on three different bases, and explicitly disclaims relying on any of the bases the commission relied on. that alone waives any defense. You cannot defend an agency decision on reasons the agency did not rely on in its own decision. But beyond that, the reasons given by Evergy are incorrect. Evergy makes 3 arguments for why the KCC has authority to regulate this act, which again is an act of registering as a federal market participant with the federal market regulator in the SPP market. So first it says there's policy reasons. This is a new field. Demand response is new. Competitive markets are new. The commission should be given some leeway, essentially, that even though it lacks statutory authority, it should have the ability to regulate anyways. Second, it points to a new statute, 66101G, which gives incidental powers within a narrow field to the commission. And third, it just straight out denies that the tariffs at issue here regulate customers at all. So as to the first, longstanding case law says that agencies have to be able to point to specific statutory authority. They cannot rely on inherent or presumed or even policy arguments.
Can they rely on a statutory grant that is exceedingly broad?
It has to be able to point to one first, and it hasn't here. So the commission pointed to 101, 66101, which gives some necessary and appropriate regulatory authority, but the Supreme Court in the KEPCO decision, consistent with a number of other states and federal courts interpreting analogous statutory language, rejects the claim that that expands the scope of authority. Instead, the agency has to be able to point to a more specific statute granting that authority. So to the extent that Your Honor is referring to 101, that broad grant, that's already been, that argument's already been rejected in the KEPCO decision. To the extent it relies on, or Evergy relies now on 101G, which has some slightly different language, that again, the text of that statute is cabined by the prefatory clause, which says, while you're regulating utilities. So while you're regulating utilities, you can have some other incidental power to do so. That does not authorize the KCC to do what it did here, which is to step outside of regulating a utility and instead regulate consumers when they are interacting with third-party federal market operators. Turning.
I mean, it seems to me, I mean, we have cases that talk about this whole bundle of the consumers. I'm not good on the precise terminology, but that there is a cooperative state and federal regulation of this whole delivery system of electrical energy. And how is this outside that sort of broad cooperative system?
So that, I think that goes to the preemption issue in this case. And there are cases referring to some cooperative federalism, but what those cases hold and what other cases hold, including NARUC decision, including New York versus FERC, a number that we cite, all say that the states have to stay within their lane, even when they are cooperating within this regime. And so states have authority, and we do not dispute that the state has authority to regulate electricity supplied by Evergy to the customer and some of the customer's loads on the system that may affect reliability and safety. But that's not what the tariffs here do. They don't directly regulate loads placed on the system, any usage that may affect system reliability, system safety. Instead, what they say is, if you go and transact with a third party, we're going to set up a checkpoint in front of the federal government's checkpoint, and you have to meet our requirements before we'll let you through to the gate, to the federal market, where FERC is the gatekeeper. And so that's not cooperative federalism. That's duplication of what's supposed to be a federal exclusive role, which is,
I mean, any request by Evergy for information from these consumers would be preempted in your view.
it is preempted to the extent that it attaches, which the tariffs here do, attach to the act of registering as a federal market participant. So if the tariffs had instead said, for example, if any customer is going to modify their load, their consumption by more than 50 megawatts within 5 minutes, you need to give us a heads up. All right, that applies to everyone. That doesn't attach to federal market participation, and it's not a precondition of federal market participation. I think that would be fine. That would not be preempted, and it was probably within the KCC's statutory authority under state law also. But again, that's not what the tariffs here do. The tariffs here don't say anything about load changes. Well, that might be the downstream intent for the commission to be able to affect those things, loads on the system that may affect reliability. The act that is being regulated is if I'm a customer and I want to sell my demand response to the interstate market regulated by FERC, I have to get permission to go through that gate in the first place. Right? And that's the problem. That fundamentally, that's the preemption problem, is it sets the state up to regulate an activity that is exclusively federal.
What does it make a difference? And I don't know whether it's true or not true, but I mean, Evergy's counsel has said it's simply a ministerial function. You fill out forms and check the boxes and you're in. Does that change the analysis in any way?
It doesn't, for a couple of reasons. One, that's not correct. The tariffs in the forms that are in the record is not just check the box. Evergy can review, quote, the accuracy of data and information provided. They can request additional documents as may be required by Evergy. And then it has to be to Evergy's satisfaction that both the information is sufficient and it puts itself in charge of monitoring the customer's performance in the federal market in compliance with the federal requirements, and can then, after the fact, deny or, I guess, rescind any approvals. And so there's not only significant substance there, but it's also incorrect that this is the only source of this information. Right? So when a customer goes to register demand response in the wholesale market, they fill out application with SPP, and the KCC and Evergy get notice of that and get that information. And so really what Evergy is asking for here is a second layer 30 days before a customer applies to the federal market to get information. And FERC has already said how much information is needed and how much is too much. And this adds another layer that is too much under FERC's view and increases the timeline beyond the 45 days that FERC decided should be the maximum for notice before participating in the federal market.
So what recourse does the retail customer have if the Evergy says this is insufficient?
Unclear.
It's unclear?
Unclear. Unclear. There's no provision in the tariff. You know, I suppose a customer could file a complaint at the KCC and litigate that for, I don't know, a year is what it took this case to get from application to decision, which is, you know, just adds another year on top of the 45 days plus 30 days that the tariffs set up, which frustrates the federal policy of kind of a painless, quick process in order to maximize the amount of participation in the market.
It was my understanding that this new tariff or amended tariff was in fact originally filed in 2018, and that customer participation and Evergy's consent to that, whether or not they consent to it, was already included in that existing tariff from 2018. Is that correct?
Partially. So there was a tariff for one of the utilities. So there's actually two utilities here. One of the utilities had a vague provision that said you need permission to participate in the federal market. The other utility had none. Right. And so for Metro, the utility that covers this area of the state, there was no tariff until this decision in 2024. So as to the first, well, as to both, right? The premise for Evergy coming in and filing for this is that demand response was just starting to take off in its service territory as of early 2023. And that was the purported need to have this tariff in place. And so there may have, one of the utilities had an ambiguous tariff provision existing from 2018, but apparently no one was making use of it until right before this tariff filing, is my understanding. It's also the case that, it's also not the case that Voltus is the only demand response aggregator that customers can sign up for or with, nor is it true that they only provide service for industrial customers. I think the only record information we have is about Voltus is that at the time of their filing in 2023, they did serve industrial customers. I don't think there's a statement that they only serve industrial customers, even at that time, nor is there evidence that they don't provide service for residential customers. And in fact, they do. Look at the.
And I had a question about the standing. It's probably kind of prosaic, but my understanding is your members, but for these reporting requirements, filling out these forms and providing the information, they would participate.
That's correct.
But did any of them participate before this and then drop out?
No, because it was just starting to take, I mean, this is the irony here. The market was just starting to take off when Evergy came in and asked for these tariffs, which then imposed the burdens. And they were so effective. I mean, I think it's evidence of the severity of the injury. They're so effective that it convinced people not to sign up in the first place. So that it kind of jumped in front of them and their intent to do it. You know, that their declarations say, you know, vote for this, I will. And the declaration from Volt Solar's manager notes that Volt Solar has customers in other states that are participating as residential customers in demand response in wholesale markets, and that they expect, because of their conversations, similar interest from the members in this state. In addition, as to standing, the declarations and the petition are not the only source of petitioners' standing evidence. In order to intervene in the KCC proceeding in the first place, Sierra Club and Volt Solar had to move the commission for permission to intervene. And as part of that, they have to show that their interests will be affected by the decision, and made that showing. It's in the record in volumes 3 and 4 of the record. And the commission agreed in granting their intervention, agreed that the petitioners, Sierra Club and Volt Solar's legal interests and participation in the markets would be affected by this decision. And so to the extent that there are findings by the commission as to their injury and their standing, it's actually in the order granting intervention before the commission and not in the final decision cites that Evergy's counsel. Again, to grant the tariff, the commission had to both point to a specific state statute giving authority to regulate customer participation in wholesale markets. There is none. It cannot point to that statute. The statute it pointed to, Evergy no longer uses to defend the decision. And even if it had the authority The decision steps into a federal market, setting up essentially a toll gate in front of the doorway to the federal market and says, you have to meet our state level requirements to our satisfaction before we'll let you into the gate to the federal market. That is both a field that is the sole domain of the federal government, and the number of additional requirements imposed by the tariffs conflict with the federal policy of a streamlined single source of decision-making on who can enter the federal market, as well as the maximum timeline the federal government says it should take to register in their market. Unless the court has other questions.
I have a question that I posed to council earlier. CURB and other interveners originally objected to the tariff, and then there's negotiation, and Evergy changed some provisions in that tariff application, as I understand it. You know what those provisions were that ultimately, because they got dropped out, CURB and the other interveners agreed to this amended tariff?
I can't speak to CURB's thinking or the other interveners' thinking. I can tell the court what my understanding changed between the original application and the final tariffs.
That's what I'm interested in.
Yeah, so the original application, the forms essentially and the tariffs said to operate an ARC in Kansas, you need our permission. So the entities like Voltas would have to sign the forms and be subject to regulation under the tariffs. In the final version, they substituted the customers, so essentially my clients, as the regulated entity under the tariffs, and said that the customers have to get permission and they have to fill out the forms and they have to sign and submit the forms to us. That's essentially the only substantive change from the beginning to the end.
Thank you.
Thank you.
May it please the court, Judge Booser, I did want to address the question which Mr. Bender did address, which the change that basically brought some of the holdouts on board to the settlement was in fact having this information submitted by the customer as opposed to the ARC, and the concern that was brought up by having the ARC fill out the forms and submit the information was that this would be seen as regulation of an ARC directly and would raise some jurisdictional issues. And therefore, this brings us back home to the fact that this is in fact regulation of impacts and burdens on the retail grid and regulation of a relationship between a retail customer and the retail provider, which is what every tariff is. That is standard regulation. That is standard right down the middle type of regulation under 66101, which is the jurisdictional basis that Evergy has cited throughout this case. I don't know where appellees are getting the idea that we didn't cite a statutory basis. We did. 66101 provides the KCC's jurisdiction to regulate the retail market and retail providers like Evergy, which is what is being done here. I do want to address a few other issues. First off, to the extent there is an argument that the court found field preemption applied, that too would be an error. Field preemption is reserved for things like immigration law and areas where truly a field is preempted by clear congressional indication. That's not the case here. And in addition, the conflict preemption, this is not this is in fact a clear exercise and I think a implementation and of cooperative federalism used properly in this context, where you have a state saying, we want to promote and allow DR aggregation to move forward. We have to make sure that we protect the reliability and safety of our distribution grid, however. And so we need this ability to understand what's going on through that process. That is clear cooperative federalism, where this regulation promotes, in fact, the DR aggregator position. So
Similar utility plans in other jurisdictions?
I'm not really. I mean, I don't know that I don't think there are any that are real specific on point. We may have cited to some states that have found similar dual federalism scopes within somewhat similar contexts in our brief, but I don't know that we have real closely similar regulation in other states.
Evergy didn't steal a lot of some other places.
Not that I'm aware of, no. It's always easier if you're not kind of leading the way. I do also, Judge Malone, want to point out the retail forms that you held up. Those are retail forms. They're not necessarily residential forms. So those really are used for retail, commercial, and industrial customers. And I think the evidence in the record absolutely shows that Voltus did not and has not operated a residential DR aggregation in the wholesale market in Kansas. That's what the record shows. The record is clear, and we have to decide the case based upon the record. On the Nehru case that was mentioned, Your Honor, I want to read a quote from that. Under the Federal Power Act, state regulators retain their authority to impose safety and reliability requirements without interference from FERC, and DERs, so the distributed energy resources, must still obtain all requisite permits, agreements, and other documentation necessary to participate in the federal wholesale market, all of which may lawfully hinder FERC's goal of making the federal markets more friendly to local DERs. That's the Nehru case, 964 F3rd, 1177 at 1181 from the DC Circuit. That's exactly what we're talking about in this case. This is a sphere reserved for the states, and that's quoted on page 39 of our brief. That's a sphere that is reserved for the states, and there's an understanding under this law that this type of documentation, permits, agreements necessary to participate in the market are permissible, all of which may lawfully hinder FERC's goal. So that is how cooperative federalism works. They bump up against each other, but I think the district court and what appellees are arguing here are let the federal government muscle the state out. Let the federal government just kick the state out of any regulation of this area. And that's not acceptable. That's not appropriate. That's why the district court's opinion needs to be reversed. If there are any other questions, I'd be happy to answer.
Apparently not, counsel. Thank you very much for your excellent briefs and your arguments, and we'll take this case under advisement and get something to you as soon as we can.
Thank you, Your Honor.
All right, the next case is from the Workers' Compensation Board. It's number 128592, Thomas Wood versus SB Manufacturing, Inc. Who do we have here for the appellant in this case?
Your Honor, Tim Emerson on behalf of the appellant respondent, SB Manufacturer.
And for the appellee?
Robert Lee on behalf of the claimant appellee, Your Honor.
Let me begin by indicating something. This is a workers' compensation case out of Wichita. Both parties are from Wichita. Both attorneys are from Wichita. I think there was some sort of a scheduling snafu as to why this case is being argued in Johnson County. And I guess I just want to note that, and I'm sorry if this caused you any trouble to come up here to argue this case.
Not at all. Not at all. Our Overland Park office is up here. It gave me the opportunity to go and visit the people who I never see on a regular basis. And some good food, barbecue.
Well, in any event, Mr. Emerson, when you're ready to proceed,
Thank you.
do you wish to reserve any time for rebuttal?
I do 5 minutes, Your Honor.
That is granted.
May it please the court. I'm Tim Emerson. I've practiced workers' compensation law in the state of Kansas for 27 years. I've practiced on the side of injured workers. I've practiced on the side of respondent employers, from small mom and pop operations all the way up to companies like Walmart and Boeing. I also practice for the Kansas Workers' Compensation Fund, which, if you're familiar with that entity, steps in when there is a situation where an uninsured respondent needs some help paying the interim bills for a claimant who needs immediate assistance with medical and wage replacement. So in those cases, I am often, if you want to put it in certain terms, on the side of the claimant or on the side of the respondent, depending on the facts of the case. And in law school, we heard that theory that we would rather let 10 guilty go free as opposed to convicting that one innocent. That never actually sat right with me. The person I thought of when hearing that was Tom Robinson from that wonderful To Kill a Mockingbird. The workers' compensation application of that would be that we would rather deem 10 rather bogus claims admissible or compensable than deny the one legitimate claim for a claimant who's navigating the workers' compensation system with a legitimate injury. When we talk about letting 10 guilty go free or letting 10 bogus claims pass through, doesn't mean we should ignore the applicable burden of proof. And here in this case, with all respect to the bodies who I've appealed on behalf of my client in this case, it looks like they ignored some things that I believe should have been paid more attention to.
Not to put too fine a point on it, but it seems to me that the bulk of your brief to us is a request for us to reweigh the evidence, because there are things that bear on the claimant's credibility. And I mean, I think the board acknowledged that, certainly in passing, but how is what you're asking us to do not simply reweighing the evidence?
I think there's a fine line between reweighing the evidence and actually considering the evidence. And the reason I say that is this: of course, the standard is under 77-621C. And I have a much more uphill battle before your honors than I did at the board level. The board is allowed to engage in de novo review. Your honors are not, but it does state when we're here in front of the Court of Appeals on a workers' compensation matter, if the action of the agency in this situation, the appeals board, was based on determination of particular facts. You look at the evidence that is substantial when viewed in light of the entire evidentiary record. And I think the arguments that I've made in the brief, and I stand by my brief, many of them, as I was citing to the record, citing to the very factually driven situation we're in here, I did worry about whether this would be seen as a reweighing of evidence as opposed to determining, here's the entire evidentiary record, why was this part not focused on and this part was focused on? I believe the evidence that was given by the two expert medical witnesses in this case that the ALJ relied upon and that the board relied upon actually had flawed information when they made their determinations, their medical conclusions that also led to the vocational conclusions. Because in workers' compensation settings, a vocational expert can come in and give opinions on wage loss and task loss, but much of it is relied upon in light of what the doctors have said. So I acknowledge the question.
Effectively asking us to declare the claimant literally incredible, as the dictionary defines that, is he is not believable as a matter of law. Do we have to make that finding to rule for you?
And I'll back up for just a second. I think you can absolutely come to that conclusion because we have.
What do we have to, though, to find for you?
I think you do. And I don't think that that's necessarily looking at the truth or veracity of the claimant. I think it is looking at evidence that possesses something of substance and relevant consequences that induce the conclusion that the award is proper. And that comes directly from the standard of review in workers' compensation cases.
That seems to me slightly aside from, I mean, I'm asking you if we have to issue an opinion that says the claimant, as a matter of law, had no credibility whatsoever to reverse. Is that your position?
I don't think you have to do that in order to reverse, but I think based on the facts that have been presented, you could certainly reach that conclusion, Judge.
I mean, that's a fairly extraordinary finding.
When looking at the standard of review, and I would invite being corrected if I'm wrong, but if I break it down into the simplest terms, it ends up with this question: would a reasonable person accept the evidence about the March 6th non-work accident? Because there were three witnesses who gave information about an accident that happened completely outside the workplace. And that accident ended up having an impact on the claim of an accident that actually occurred at work. It was only after hiring counsel and only after it came time to sit for a deposition that his story completely changed. And there is nothing that supports that story other than the claimant's testimony himself. Looking back at the original information that was gathered in the case, we actually have three people who are able, including the claimant himself, who are able to describe an accident that happened at home, falling into a bathtub, a rather significant event. They want us to conclude later on that, well, that wasn't as significant as the second event where he lifted 17 pounds. We have the testimony of claimant himself saying that he couldn't walk, he had to lay down, he had difficulty even getting up to go to an appointment after the bathtub incident at his house. Dr. Zotterer comes in and says, this is what I was told. He had an accident at his home. It was significant enough for us to give him a Toradol shot.
I'm sorry, I didn't mean to interrupt. I've read the brief. I mean, I understand the argument you're making and the evidence you marshal about credibility or lack of credibility of the claimant. Is it your position that the claimant's representation that he was actually injured in August is false, and that we should conclude that there was no injury at all?
We made that argument later simply based on the stories that he told during his testimony. He gave testimony multiple times in this
Again,
case.
do we have to make that finding or that determination to reverse?
I don't think you have to make that determination to reverse, but you could certainly come to that conclusion. We later wanted to change our stipulations to indicate, because based on everything that we have heard to that point, we have the claimant's own testimony, we have Dr. Zotterer's testimony, we have the text messages that he sent that week in March where this accident in a bathtub at home occurred, the same week in March that he later testified at his first deposition that, well, I was lifting a tire off a street sweeper at my employer's business during a period of time that he wasn't even working. He wasn't even there to have done this.
Well, that's a little bit squishy.
I think the evidence was pretty clear. He was gone from March 7th to March 11th.
Right, but he was sort of hedging on what the precise date was that he had reported it, right?
He gave 2 dates, March 7th and March 11th. And neither of those days was he actually there. And there's testimony from his supervisor that here's his schedule. He was not there. He was at home because he had a home accident and was being treated and texting us contemporaneously with the description of the treatment that he was receiving during that period of time. I just think that is an absolutely significant event that the administrative law judge completely ignored and the appeals board glossed over and rubber stamped it. All we got out of them was he's a dubious historian. I don't know if that's a fancy term for, well, it's questionable, or if it's a fancy term for he lied, but we're going to let him get away with it.
There were two doctors that the ALJ and the board relied on, as I understand it. One of them, I think, was Dr. Erickson. Is that correct?
No, they did not rely on Dr. Erickson. I wish they had.
Okay, so what, do you recall the two doctors that, am I correct that?
Yes.
Okay,
Yes, Judge Boozer. The two doctors that they relied upon are best described as work comp doctors because they're doctors that we see on almost every case. And what I believe was done at the administrative level was Judge Klein looked at what Dr. Hufford, who he's very familiar with, said. Dr. Hufford was the court-ordered IME. He was the doctor who was giving the court what was supposed to be a neutral opinion. Pedro Marotti is the other doctor, and
for the plaintiff.
yes, and I don't think I'm stretching to say that he's very claimant friendly. I could likely walk into his office right now and be found disabled.
Here's the question. Did these two doctors that were relied upon, their opinions were relied upon by the ALJ and the board, were they aware or informed of the bathtub incident?
They were not. Dr. Marotti was not, at least not by me, because I knew that would not make a difference. Dr. Hufford was the doctor whose deposition some of this evidence came in very late in the case. And that's just the nature of the procedural manner in which we try cases in work comp. The first full hearing is a regular hearing. There are depositions taken before that, but evidence is put in after that, typically over a period of about 60 days.
And were both of these doctors then, they were not informed of the bathtub incident in any way through medical records or prior testimony, but were they informed as to the so-called tire incident?
They absolutely were, and they both put it in their records that this tire incident occurred, and I think the substantial competent evidence demonstrates that it never occurred. It certainly didn't occur.
You're going into your rebuttal time.
Yes, thank you.
Mr. Leahy.
If it please the court, Your Honor, I think that you do have to find that the claimant's credibility is suspect all throughout this claim in order to reverse. And that just isn't supported by the facts. We had no.
Mr. Wood has some credibility problems.
Well, he does, but I think it's more of a memory problem than it is a credibility problem. When he was injured in March of 2022, he did not feel that that was a significant injury. He never requested medical treatment from the respondent. They never offered any treatment.
Description of the mechanism of injury changed substantially.
His, no, I don't believe his description of the mechanism of the injury ever changed. I think what changed was the fact that he couldn't remember the date on which the lifting of the tire injury occurred.
Isn't there fairly clear evidence in the record that he went to the chiropractor in March, and there was a discussion about him falling into the bathtub? I mean, I gathered he was cleaning and he fell into it and injured himself. Then later at his deposition, he's talking about an on-the-job injury in March, which has prompted you to initially file a claim based on that. No, you didn't file a claim?
We did file a claim, but not initially. That was not our initial claim.
After the deposition you did.
Right.
But, I mean, those are, the gap between a work injury and injuring yourself in the bathtub is pretty monumental, isn't it?
I agree. He definitely did not injure himself at work on March 9th of 2022. He wasn't working that day. I think that Dr. Zouderer, the chiropractor that he saw, her history that she took was that he injured himself when he fell in the bathtub. I think that's true. But if you look at claimant's testimony to virtually every doctor, is that he hurt himself once or twice a year at work, didn't report it. He went on to work. He had a very heavy job as his supervisor testified to. And I don't think that he saw the injury in March. He didn't remember it clearly, obviously, even from the very first time he testified to it, he didn't remember the date on which it happened, but he didn't see that as significant. And I think that's important.
Did your client ever admit to falling in the bathtub?
I think he did admit to falling in the bathtub, and he didn't remember when that happened either. But I think that he did, on cross-examination, admit that to falling in the bathtub. But it wasn't a significant injury. If you look at it, he saw a chiropractor one time. She provided an injection. She didn't ask for him to come back and see her again. She didn't make any referrals to any other doctors, and he went back to work doing his regular job. Now, there is testimony that he had help doing his regular job.
That's exactly what I was going to ask about, is that late in the process, the employer comes forward with various employees who say they assisted Mr. Wood after the March incident for some extended period of time. How does that impact the opinions of the doctors? I mean, particularly Murati and the independent medical examiner whose name escapes me at the moment.
If you look at the testimony of doctors Murati and Hufford, whom the ALJ and the board relied on, what they said was that the impairment that they gave and the work restrictions that they gave are there because exclusively from the August 19th, 2022 injury and not from the March 9th, 2022 injury. And the reason for that is because he didn't receive any treatment following the March 9th, 2022 injury. No doctor placed any restrictions on his activities. Why the employer provided help with his heavy lifting, I don't know. There was no doctor that said he needed help with the heavy lifting. And he only saw a chiropractor one time. He didn't receive any significant treatment.
I mean, I assume the employees were helping. I mean, I didn't read the deposition, but I assume they were helping because he asked for and needed the help.
There's no testimony that he asked for or needed that help. The testimony is that they provided that help. His supervisor said that the only help he instructed other employees to provide was lifting the heavy tires and wheels. That's the only thing he said, and that they did it occasionally. If you look at the three witnesses who testified, they said, well, we were there working in the paint booth, helping him 2 hours a day, every day. Well, that's 6 hours. That's half the time that they worked in a day. I don't think that's very credible. And I don't think an employer would provide that when there was no medical evidence to show that he needed that help following the first injury. He had no restrictions on his activities. He didn't receive any treatment other than one visit by a chiropractor, and that was it. And that's exactly why Dr. Murati and Dr. Hufford found that the August 19th injury was a significant injury because he was injured. He saw a chiropractor for 3 months. Respondent then authorized him to see Dr. Moore. She orders an MRI. First time he has a test to objectively determine what's going on. The MRI shows two herniated discs. They authorized Dr. Erickson, an orthopedic surgeon. Erickson goes in, wants to provide treatment. My client doesn't want anything other than holistic treatment. It's just the way he is. He had one shot, I believe, maybe not even a shot from Dr. Erickson's office, but all he had was physical therapy, which he testified didn't help. And so that was the main reason that Doctors Hufford and Marotti testified that the August 19th injury was the significant injury that led to the restrictions that they placed on him and his work disability.
When they offered those opinions, were they aware of the assistance to whatever degree it was other employees were providing Mr. Wood between March and April?
I don't believe so. Yeah, I don't believe so.
Does that render their opinions not credible?
In my opinion, no, because there were no medical doctor or even a chiropractor had placed any restrictions on his ability to work. Nobody ever did. Even Dr. Erickson felt he didn't need restrictions to work. And that's why Hufford and Marotti said that the August 19th injury is the significant one, because he didn't have significant treatment after the first injury. Nobody provided any limitations on his activities and restricted his work. I mean, the employer wasn't bound to modify his job activities, because no physician had ever indicated that he needed a modification of his job activities. And his supervisor, Mr. DJ Feast, said that he went back performing his regular job with the exception of lifting the heavy tires. And his regular job, if you look at the job descriptions from Paul Harden and Steve Benjamin, was a very significant heavy job. And he performed that job from March through August 19th. It wasn't until August 19th that he saw medical doctors who provided treatment and placed restrictions on his activities for the first time. And that's when the employer had an obligation to modify his job and put him on part-time activity. And I think that was important to Doctors Hufford and Marotti. And the board and the ALJ's decisions are supported by substantial competent evidence. They have two doctors that testified that the August 19th claim was the claim that resulted in all of his impairment as a result of this injury, and the restrictions that were placed on him, which resulted in a work disability. So that is substantial evidence.
Did the ALJ or the board have allowed the redeposition of Dr. Hufford to provide him with, I presume to provide him with that additional information and determine whether it affected his opinion?
The ALJ, Mr. Emerson scheduled a motion with the administrative law judge to request that the ALJ give him additional time to take Hufford's deposition. And the ALJ was aware of the testimony, heard Mr. Emerson's arguments, and knew the facts of the case by then. And it's reasonable and within his discretion to exclude that testimony. He allowed the testimony of the three witnesses, the workers that assisted my client when he didn't have to. They were beyond the terminal dates, but refused to allow him to go back in and examine Dr. Hufford. And I don't think, at least I can't see that Dr. Hufford would change his mind. The claimant wasn't restricted or placed any limitations placed on his activities. The employer did not have an obligation to provide any of that help. And so I can't see that Dr. Hufford's going to change his mind based upon testimony that three people helped him perform his job. And
Would it be better, at least for us, to know whether he would have or not?
well, I don't know the answer to that question, maybe, but when do you put a stop to the placing of additional evidence into the record? I mean, this guy was hurt almost 4 years ago. The last injury was almost 4 years ago. And here we are in 2026. A significant amount of evidence was placed into the record. 13 depositions, I believe, 13 transcripts were placed into the record. When do you say, well, that there's been enough here? And especially in light of the fact that no restrictions were placed on him by any physicians. Why did they offer that help to him? We'll never know the answer to that question. Regardless of
Refresh my recollection, what did the ALJ say about the bathtub incident as it relates to his decision? Did he say anything?
as it relates to the ultimate work disability, the ALJ concluded that it was not a significant injury.
And the board accepted that
Correct.
from the ALJ.
Correct. I mean, the board read, they're a finder of fact. They read the evidence and made the determination that the first injury was not a significant injury, did not contribute to the restrictions or the impairment rating, as the two doctors testified that it didn't. And they agreed. They felt that it was substantial and competent evidence to have two licensed physicians indicate that the second injury was what resulted in the restrictions, which gives rise to his ability not to earn as much money and the ultimate determination of work disability.
And lastly, how did the ALJ evaluate the workers who testified that they were helping the claimant after that initial injury?
He recognized that they made those statements, that they testified that they did help the workers. But I don't know that he felt that was significant or commented that much on that.
He didn't make any credibility findings that the workers were not telling the truth.
He did not. He did not. But I think that you have to find that the ALJ abused his discretion when he decided not to allow respondent to take Dr. Hufford's deposition again. And the board has always said that they're not going to interrupt the ALJ's determinations in that regard, that he should have discretion to control his docket. Anything else?
Apparently not. Thank you,
This went
Council.
a little different direction than I anticipated, but that's okay.
Now I have to ask you what
What
you thought it was
direction?
gonna go. What do you think we should have been asked?
No, I agree. I agree that you answered the right or asked the right questions. So thank you.
Before you jump in, let me phrase this correctly, and I have no expertise in work comp other than what I've learned as an appellate judge. You are not contesting the computation of the award here. I mean, that's not an alternative argument.
Not at all. We believe the award was based on the wrong physician's opinion on permanent impairment. We absolutely believe.
Right, and again, without sort of suggesting how we come out, but if we essentially credit or affirm the board, you don't have an alternative argument that Wood is getting too much.
That the calculation was wrong. No, I don't have that argument. Calculations were correct if in fact he sustained a 61% work disability.
Well, I assumed that from the, I just wanted to be sure that I wasn't overlooking something.
Okay. And I feel like I'm going to need to talk like an auctioneer, and I apologize in advance for that. This wasn't a situation where you've got a claimant with memory problems. I think the board was being kind when they said he was a dubious historian. That phrase has stuck out in my mind since they issued their order, rubber stamping what Judge Klein did. The answer to some of these questions about how did the judge deal with the information from the three coworkers, he dealt with that in about 3 sentences. He dealt with the backwards fall into a tub just by referencing that a doctor said it. He didn't do any kind of analysis of it or the significance of that event on the subsequent injury. The fact that this is being referred to as that first event was not significant. If you look at the fact citations to the record, claimant couldn't walk. Claimant went into Dr. Zotterer's office, bent over at the waist because he couldn't straighten up. When you look at his subsequent description in his testimony of what that first injury was like, he describes it as extremely significant. He even says later, I was working with a hurt injury. He was referring to when he went back to work after the March event, and he had to use the help of his coworkers in order to perform his job duties. So to suggest that he was actually returned to full duties, and that's what Doctors Hufford and Murati based their medical conclusions on, were two things. Well, he didn't get a lot of treatment. Claimant himself said, we're holistic. We treat ourselves. It's not uncommon for claimants' attorneys to ask doctors specifically, don't give us any restrictions. Don't give us restrictions on this particular case. They do it for strategic reasons. That doesn't apply in this case, but this gentleman made it clear. I'm going to use MSM powder. I'm going to use turmeric. I've got a back brace already and some naproxen. I'm going to go that route because I don't want a lot of treatment. When he ended up treating with Dr. Erickson, he did the same thing. Dr. Erickson informed him, hey, we have an injection that can help you. What do you want to do? I declined that. Well, he sure accepted it after that first event in March when he fell in the bathtub. He had a very aggressive pain modality offered to him, and he accepted it because he wanted to be able to stand up again. He wanted to be able to walk upright. And we've just, the amount of evidence that supports from three different witnesses in this case that supports that that first event was extremely significant. For me, it was very significant event, lifting a 17-pound spring assist door, very insignificant event. Doctors Murati and Hufford only had the information from him that on March 7th, on March 9th, on or about March 9th, it's still that time frame within which this one injury of two, and that's claimant's words, we're only talking about two injuries. So his two injuries had to be that subsequent lifting of the 17-pound garage door and something that happened in March, because he consistently, in his treatment with the docs, consistently said, 5 months ago, something happened. 5 months ago, something happened. He was only honest to the doctor who treated him contemporaneously with that March event that did not happen at work. And I think that has a significant impact on that later injury, because that was an aggravation. Claimant described it as that in his own words, a re-injury. Claimant described that in his own words. Our statute doesn't allow for that to be a compensable claim. Our statute says that you don't get compensation unless there's impairment above and beyond what it was before, if you've got a pre-existing condition. And he did, and it had nothing to do with his work. So we ask that the board's order in this case be vacated, or in the alternative, I'd love to have what I had in the Turner versus Pleasant Acres case that was cited by Mr. Lee, which is a suspension of terminal dates so that we can get the information to the physician. In that case, it was also Dr. Hufford. That was allowed in Turner versus Pleasant Acres. He got the information that he wanted, and he changed his opinion because he determined that the claimant wasn't being forthcoming with the initial information. So that's what we wanted in this case. Unfortunately, it was denied, but I think this court has every jurisdiction to remand the case and allow us what we requested in the redeposition of Dr. David Hufford.
All right, counsel, thank you for your briefs and your arguments. We'll get something out to you as soon as we can.
Thanks so much.
Question. Can we go to the last hearing?
I'm fine.
All right, the final hearing this morning is from Johnson County, 129-221. Amir Kenyatta and Megan Florence versus Brittany Sofa. Probably mispronounced a lot of that, and I'm sorry. Anyway, who do we have here for the appellant?
The court, please. The appellants appear by Michael E. Whitsitt, their attorney of record.
And for the appellee?
When Your Honor, Andrew McGrew appears for the appellee.
All right, Mr. Whitsitt, you wish to reserve any time for rebuttal?
2 minutes, Your Honor.
That is granted.
Thank you. Yes, the court, please. This case involves a residential lease from Olathe, Kansas.
And it was a single family residence. My clients were the tenants. It therefore is under the Kansas Residential Landlord Tenant Act. I'll refer to it as the KRLTA. And what my clients, the appellants, want in this case is a reversal of the trial court's finding that my interpretation is that the trial court found that there were two liquidated damages provisions in this lease, and that the less heinous, the smaller of the two, was going to be enforced by the trial court, 1 month's rent. The other provision in this 32-month or 32-page lease was at the very end in an addendum, and it provided for a $3,000 early out. I call it a penalty. That's of course not what it called it. The trial court judge called it liquidated damages. And we believe that under the KRLTA, there is no ability to provide for liquidated damages in a residential lease. And that's what
liquidated damages clauses are prohibited in residential leases.
Yes, sir.
You have an alternative. I mean, if you don't buy that, I mean.
Well, I did discuss it reluctantly in my brief, which is the idea that these have to be looked at. If you allow them at all, they have to be looked at critically in terms of whether or not, in substance, they provide a windfall to the landlord, as it did in this case. Because in our case, the case at bar, the landlord admits having suffered no damages. In fact, the landlord found a new tenant at $2,550 a month instead of $2,335 a month.
You look at liquidated damages prospectively, right? Not after the fact.
If you allow them at all. You're talking, I think, about the Carruthers line of cases. And I don't think.
If we're allowing this, 3,000 or even a 1 month's rent liquidated damages for an early termination, as your clients did, what's unreasonable about that?
Well, the windfall that the landlord.
There was a windfall here.
There clearly was. And the fact that, and we all understand, I think, that residential leases are not freely negotiated between the parties. It's a matter of landlords having the high ground. The tenants have to basically take what they've been offered by the landlords in the lease. And so it can't be treated, in my opinion, as it was in Carruthers. Instead, you have to look at the facts of the case when the breach, if you will, when the early termination occurs, and what then happens with the lease itself. I don't think there's any easy way to look at a liquidated damage provision under the KRLTA and find that, oh yeah, it's just clearly enforceable, as the trial judge in this case did. And it's in looking at these, at the law, it looks like it's the Shoot case, the 2024 case that brought in a consideration of Carruthers, and then it ultimately found out or determined that unconscionability was the basis for throwing out the provision in Shoot. But in my experience, I've seen, well, Mr. Brand back in 1975 suggested that this was an acceptable provision to put in a lease. And in the 10 or so years I've been practicing landlord and tenant law, I've seen these repeatedly. And it's not practical for tenants to appeal these to your court or to the Supreme Court. It just doesn't make any sense. And therefore, landlords, again, have the benefit of having a provision that nobody's going to argue about. And in this case, the trial court judge didn't argue about it. He found it.
As I understand it, either payment required here, whether it was the $3,000 or the 1 month's rent, was to cover the expenses of reletting premises. And it had nothing to do with excusing payment for rent for the later months on the lease.
To be clear, the first provision, which called for 1 month's rent, that's all it said. It didn't say what it was for. It just said that's an early out fee. The later one, the $3,000 fee, yes, it talked about expenses of reletting, thinking about what they had to do, and more importantly, it didn't waive future rent. It said you've got to pay this $3,000, but that doesn't excuse you from the possibility of having to pay future rents if we don't rent the place out. So I think that later provision, which the judge did enforce, thankfully, was clearly, or should be clearly deemed to be unenforceable.
I'm not sure if I read this that way.
You're at the addendum.
Yeah,
I quoted
it
language.
doesn't excuse the rent that's already accrued. But are you saying this allows the landlord to get $3,000 plus future rent?
Yes, and I quoted the language in my brief. If you want me to, I'll pull out the brief.
I can look at that.
Yeah, it shocked me too, but it doesn't matter in the sense that the judge didn't enforce it. He enforced the less heinous of the two provisions. And I think we've already discussed the fact that my clients, the tenants, notified the landlord they were going to get out early. The lease didn't end until December. It was May of 24 when my clients notified the landlord they were getting out. Both parties worked to get the property vacated. My clients left June 18th. On June 21st of 2024, the landlord had new tenants in place at higher rent, $2,550 a month instead of $2,335 a month. And nevertheless, landlord one time wanted to charge rent for the month of July, for which she already had a tenant and had backed off on that since then, and had distilled it down to, well, no, the landlord wanted $3,000 for the early out termination, and Judge McEntee decided, no, $2,335 is what we're going to enforce, which is from paragraph 4B of the original lease.
Mr. Whitsitt, as I read the addendum, there was the requirement that even in addition to the $3,000 and the $2,300, that the tenant would be required to pay the remaining unused months in that lease.
That's the way. Well, it's a very long addendum, but it does say that.
So my question is, does that last part where it says you have to also pay the months that you're not living here anymore, but you broke the lease on, does that really affect the character of the $3,000 liquidated damages or whatever you want to call it, the early termination fee?
I think so. It makes it a penalty, basically. It doesn't serve to compensate for damages if the landlord's reserving the right to charge for future rents or any other damages the landlord might suffer. That makes it pretty clear that that provision, the addendum provision for $3,000, is nothing but a penalty, in my opinion.
You would like that to be our opinion.
Well, that would be the ideal, yes. Well, I find it interesting that we have to deal with all these provisions landlords throw into the leases, when to me, the KRLTA pretty clearly doesn't allow that kind of thing. And here I am arguing with you folks about that when I think the KRLTA is clear about that. And this business about bringing in Carruthers, I think is inappropriate because that's the language that relates to commercial contracts, not KRLTA leases.
Well, is Carruthers relevant, though, in a discussion of what constitutes a liquidated damages provision?
Oh,
It's not analogous factually, but I mean, its discussion of liquidated damages seems to be the most recent and best discussion by the Kansas Supreme Court.
I agree. Clearly, if you're into that discussion about liquidated damages, but I guess our position, the appellant's position, is those have no business being discussed in a KRLTA case. In a landlord-tenant lease, you can't slip in a liquidated damage provision. It doesn't work. Now, I think there's a lower ground that you could take in regard to, oh, okay, liquidated damages are okay if you do this, this, and this. And I outlined that in my brief, but I don't think it's right to go there because the KRLTA is different than commercial contract law. The bargaining power of the parties is distinctly different. And the only one who writes a lease is the landlord. And so That's why the KRLTA was enacted, to give some equality to these parties, the landlords and the tenants. And if we allow any kind of liquidated damages provision in one of these leases, we're effectively backing away from the benefits conferred by the KRLTA on tenants. I discussed several things that in my brief, probably more than I should have. Unconscionability, for example, I don't think it's necessary to get to unconscionability, although it clearly, this provision or these provisions in this case were clearly unconscionable because of the facts, the surrounding facts and circumstances. And I think I referred to this earlier, and it's the unique facts of this case make it clear that the landlord got a windfall out of this provision. If it's enforced, the landlord gets $2,335 in addition to rent that she never lost in the case. In fact, got the benefit of higher rent because my clients backed out of the lease early. Does this time include my rebuttal, or is this?
No,
This is 13 minutes?
rebuttal.
Okay. And I talked in my brief about measure of damages for the breach of a lease. And I think another factor that needs to be considered is the KRLTA does contain, I think it's in 2547, a provision for mitigation, a requirement that the landlord mitigate its damages. Well, if you use this liquidated damage provision, where does that mitigation duty go? I think it goes away, and that's not right. The statute again requires the landlord mitigate. That's really, I think, the substance of my argument. Thank you.
Thank you. Mr. McGrew, let me just lead off with a question. If your client hadn't rented this property out so quickly, would she have been allowed to sue for the $3,000 plus the unpaid rent that was never paid?
The forward rent after the termination date? I don't believe so, Your Honor. I do believe that the language of the addendum, to the extent that it can be read as requiring future rent, I believe it's unenforceable. I think it's just the product of poor drafting rather than something that they would try to enforce.
We're talking about the sentence, tenant is still responsible for all obligations under the lease, including paying for all rent due, damages, and other charges, right?
Yes, Your Honor. I believe that was intended to say that up until the termination date, the tenant would remain responsible for the rent up until then, but not require them to pay ongoing rent in addition to the liquidated damages provision. I certainly would have drafted it better myself, but I think that was the ultimate goal there.
Well, it wouldn't be much of a liquidated damage clause if it allowed the double recovery, right?
Absolutely correct. And to the extent that is a potential problem here, I believe that can be removed. It's an unenforceable provision in the case of a liquidated damages, but it can be removed without affecting the rest of the addendum, which I believe squarely does provide for those liquidated damages. The primary issue in this case is really not even about actual damages or settlement, it's about whether or not the parties can settle their agreements at any point during the relationship of the parties. Strictly, just as a matter of public policy, it's really in the best interest of all parties, landlords, tenants, and the judiciary, to allow these liquidated damages or early termination fees to be enforced. They are advanced settlement agreements made in the anticipation of the actual damages that will come up in the event of a breach. Arguments about security deposits, actual damages, all of these things, windfalls, these are all red herrings because they don't actually go to the main issue. The crux of the issue is the ability of the parties to enter into a settlement agreement to resolve their issues.
In looking at Crothers, again, not as analogous factual authority, but as a good discussion of liquidated damages clauses, it seems to indicate a liquidated damage clause must resolve all damages flowing from the breach. Would you agree with that?
I do believe that's correct, Your Honor. I believe that the intended goal for a liquidated damage clause is to, as the court said out in Crothers, the three main goals are to encourage settlement, to avoid litigation, and to allow the parties to live and operate under their agreement.
By providing a fixed dollar amount that resolves all damages flowing from the defined breach.
Correct.
I'm having a hard time, and help me here, why either provision in the lease for the payment is then a liquidated damage, because it does seem to allow the landlord to continue to seek unpaid rent through the balance of the term if they're unable to mitigate. They take reasonable efforts and can't, but they still are able to, or, I mean, there's an acceleration clause that allows to sue immediately for the unpaid rent on the balance of the lease term. So explain to me how these wind up being liquidated damages clauses.
Well, so I think that it would, and again, I do believe that's kind of the product of just poor wording. I believe that the intent was to just require.
Well, except that what we look at is the wording. I mean, it's a written contract, and the landlord had whatever ample time to do this. Obviously, somebody spent a lot of time on it, and it. I mean, we are in this situation probably to strictly construe it against the landlord as the maker. So, I mean, poor drafting doesn't seem to me to be a defense here.
Well, and so I think that it does go more towards the attempting to construe or to garner the intent of the parties as it was when they entered into the agreement. This was originally drafted with the intent of fully resolving the issues between the parties to the extent that there would be a breach or there would be an early termination of the lease agreement.
Well, how do you read it that way?
Absent the provision that allows the recovery of future rent, had that provision been removed, if that is judicially removed, and the rest of it is remained intact, I believe it falls much more
right.
closely.
We're supposed to look at the intent of the parties based on the language in the contract, not what we strike out as being legally unenforceable, right?
Correct. And
I mean, how does that, I mean, the intent was, geez, if the court looks at this and says, this is really bad, we don't mean it. I mean, that's your argument, isn't it?
not necessarily, Your Honor. I do believe that the crux of my argument is that the parties intended for there to be some remedy if there is an early termination. So if there is an early termination, there's an amount that would be paid. I believe if my client did try to recover rent beyond that period of time, that would be invalidated by the contract interpretation. But they did not try to recover any rent after the period of termination. They're just seeking the early termination fee that the parties agreed to.
Well, that's because they had no damages. I mean, but I had something disappear. Go ahead.
If we don't allow the enforcement of the clause in this case, has your client suffered any actual damages?
Well, Your Honor, I think the care of this court does provide instruction on that, to where the retrospective analysis is not one that should be considered in liquidated damages. So to the extent that the liquidated damages is completely, or sorry, the early termination addendum is completely removed from the agreement, my client in this particular case has not suffered any damage.
So I guess what I'm getting at, there would not be any need for us to remand this back to district court for a determination of actual damages. You're basically conceding there is none. Is that right? I'm not forcing you.
No, I want to make sure I'm giving you the correct answer. I don't believe that there are any actual damages. My client was fortunately able to re-rent the property fairly quickly. However, that's not always going to be the case. And these kinds of provisions help protect not only landlords, but also tenants from the uncertainty, the difficulties that come along with trial, with litigating these issues. For example, if we picture a situation where these liquidated damages are not enforceable, or if they're not permitted under the KRLTA, like the appellant's arguing, we would be in a situation where immediately upon the tenant's notification, hey, apologize, terminating my tenancy early. I know it's only been a couple months, but I have to move across the country, or I'm starting work somewhere else. All of a sudden, the landlord has to file a lawsuit immediately, even before the termination date, which is permitted by the KRLTA. The first appearance date, tenant likely hasn't moved, and so they have to request a continuance. So immediately upon filing of this action, there's already 2 court appearances that are required. And then no decision can be made. Nothing can actually happen until the landlord re-rents the property and determines their actual damages. So we may have 3 to 4, 5 different appearances, at which point the tenant's going to be frustrated, arguing that you're not making reasonable efforts. You should reduce the rent. You should advertise more. You should make more of an effort to be available. And then all of a sudden, the district court is in a position where they are having to determine what's a reasonable rental value for this property. What are reasonable efforts? If the interest rates go up, or if there are added expenses for landlords in this case, how much, or what's a reasonable value? And all of a sudden, the district courts have to become real estate professionals rather than legal professionals. And so it gets to a point where after 5, 6 appearances, the tenants probably had to miss work to make these court appearances. The landlords had to hire an attorney, and they're several $1,000s in the hole. At that point, the parties say, we need to put a cap on this. I'm tired of coming back to court. I'm tired of spending this money. Let's just resolve the case now. I'll pay you a month of rent, a month and a half of rent, just to make this go away. The landlord stops incurring damages. The tenant stops having to miss work. The tenant's future damages are stopped at that point as well. And so we end up in the same point that we would have been had the liquidated damages be enforced and been enforceable under the KRLTA. And so for these reasons, these kinds of provisions protect the landlords. They protect the tenants from possible expenditure, and even protect them from, none of my clients would do this, of course, but potentially uncouth landlords who would want to charge more, want to possibly, as is Mr. Whitsitt suggested, might overcharge. And if they don't get a new tenant in there, so be it. They have someone on the hook for actual damages.
So what about the circumstance? Now here you have the tenants moving about halfway through the lease, roughly. So there's like 6 months, and it's a fairly significant rental payment. If you had a liquidated damages clause like you're describing, is it reasonable though to apply the liquidated damage to someone who moves out, say it has an exigent circumstance and has to move out in the 10th month or the 11th month, as opposed to someone who's voluntarily taken off halfway through the year?
In the situation where the liquidated damage provision, it would be very fact specific. So for example, in a situation where they require 30 days advance notice of the termination. If you're in the 11th month and the lease is getting ready to expire, depending on the language of the lease, the landlord may say, well, they haven't provided their notice of intent to vacate yet, so the lease is going to renew for another year or another 6 months or whatever period that might be. In which case, if the tenant hasn't provided notice and suddenly has an exigent circumstance, they would be in a situation where the landlord's already anticipating an extension of the lease based on the terms. Now,
Take that out of it.
Sure.
That's not in the hypothetical.
In the situation where the lease would come to an end, then in the event that it gives the landlord a windfall, I would argue it's not enforceable. The tenant would be responsible for paying their rent up until.
Isn't that a retroactive examination that we're not supposed to make?
Not necessarily. I think that this is distinguishable. It is still a retroactive examination, but instead it goes to the conscionability of the provision. And so to the extent that, for example, if a tenant leaves 2 weeks before the actual termination date of the lease, and the landlord says, well, you owe me a month and a half of rent, then at that point, they wouldn't have otherwise been entitled to those amounts. And so it does require some kind of finessing at some point. But in the case of Barr, there are several months where the landlord was anticipating to have this rental income, was planning on it.
My limited experiences at limited actions do a lot of finessing. But
And I do believe that would probably have to be the outcome there, in which case it's very reasonable for the parties to come to court and have that conversation, should that be necessary. But in a situation like this, where there's 6-7 months left on the lease agreement, the landlord isn't anticipating the potential non-renewal of that. So they're anticipating 6 to 7 months of actual tenancy, actual income. And in the event that that's suddenly removed and taken out from under their feet, they have to scramble. They have to try to locate a new tenant. And in this particular case, the landlord is not a professional landlord. The landlord is an individual. She has a full-time job, works regular hours, leaving the only time for her to act as a landlord or property manager in the evenings and on the weekends. Severely limits her ability to get new tenants, to locate and bring them in, which goes towards the enforceability of this particular provision, because the landlord needs to have that added security. She'll need that extra time to try to bring a new tenant in.
Counsel, I just want to make sure here that you do not have a Kansas Supreme Court or Court of Appeals case that upheld a liquidated damage award in a KRLTA case.
That's correct, Your
Is that
Honor.
fair?
That's correct. So this is, I believe the closest is Carruthers. Not directly on point, but I do believe that is instructive for purposes of determining the public policy, which is to encourage settlements, to avoid litigation, and to allow the parties to enter into these agreements and live by them. For those purposes, I believe that tenants and landlords in the residential aspect do have those same interests. They want to resolve the cases without having to come to court several times. They want to avoid the cost and the uncertainty and the potential several months that could go by where a tenant might be on the hook, even if the landlord is actually using reasonable efforts to re-rent the property. To that end, we believe that this provision is reasonable, that's enforceable, especially in a KRLTA situation. And if the court has any other questions, I'm happy to try to address them.
Apparently not. Thank you.
Thank you.
Just a couple of things, if I may. I think that the appellant's position, which is we want a clean line. Liquidated damages provisions and KRLTA leases are not acceptable under the law, is the way to go. There are subtle ways to get around that, and I talked about that in my brief, but I don't want to belabor that because I think the right answer, because of landlords, and my worthy counsel here has highlighted the fact that landlords are creative. Since 1975, when we got the KRLTA, they've been working ways around the prescriptions of the KRLTA. And if this court or the Kansas Supreme Court allows them any wiggle room, they're going to take advantage of all of it.
And as a tenant, I'd want a liquidated damages clause. Anything to get me out of being responsible for the entire lease. That seems reasonable and fair to me.
Believe me, some do. I've talked to some who preferred the liquidated damage approach to paying me, if you can believe that. I know that's hard to believe. And I think that counsel's discussion about protracted litigation is just, it's imagination, a good imagination on his part, because I don't know of any landlords, in my experience, who will file an eviction or sue for damages before the tenants actually left the premises. That's a very creative scenario that he presented to this court, which in my experience doesn't exist. Thank you very much.
All right, counsel, thank you both for your briefs and your arguments. We'll take it under advisement and get an opinion out to you as soon as we can.
Thank you.
And with that, court is in recess until 1:30 this afternoon.
Does that include my 2 minutes of rebuttal? Is it gone already? What, did they give me 15 minutes to start? Or was it,
I think it was 13.
Okay. That's what I thought he said.
Well, yeah, you kind of get up there, you get that time.
Goes by fast.
Please be seated. Good afternoon, everyone. Welcome to the May docket of the Kansas Court of Appeals sitting here in Johnson County. I'm Thomas Malone. To my right is Judge Gordon Atchison. To my left is retired Judge Michael Boozer, especially signed to this docket. We're the panel for your cases this afternoon. We only have 2 hearings this afternoon. I'll call the cases in the order of the published docket. When I call your case, please come forward. We'll get your appearance, especially if your name might not be on the brief. We need to make sure that's correct. As you probably know, we've read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. As the presiding judge, I keep track of the time. Each side's given 15 minutes for your argument unless it's designated differently on the docket. I don't think we have any of those this afternoon. The appellant's attorney should let us know in advance if you wish to reserve any of your time for rebuttal. If there's more than one attorney per side, also you need to let us know how you're going to be dividing up that time. After we hear your arguments this afternoon, your case will be deemed submitted for decision, and we'll take the case under advisement and get a written opinion out to you and your clients just as soon as we can. So with that, I'll call the first case on the docket. It is from Douglas County. It's number 128669. The Board of County Commissioners of Douglas County versus Walter and Cheryl Spencer, and also Gary Ziegler, a third party. The council want to come forward on that? The appellants are the Spencers. So who do we have representing them?
Good afternoon, Your Honors. Mark Epstein on behalf of the defendants, appellants, Walter Spencer and Cheryl Spencer.
All right, and who will be arguing for the appellees?
Good afternoon, Your Honor. Appellee, the Board of County Commissioners of Douglas County is represented by counsel Jeff Hyman.
And the Ziegler?
Your Honor, the third-party defendant, Gary Ziegler, I will handle the argument. My name is Todd Thompson. We had a medical emergency yesterday, so I'm sort of a last-minute substitute, but I'm not on the cover of the brief, but I will be making the argument. Jason Pryor is here with me today.
All right. And have you two decided how you're going to split your time?
I think so, Judge. I think the county would take 12 minutes if that's approved, with Mr. Ziegler's counsel taking 3 minutes.
Whatever you agree upon is fine. So,
And Your Honors, if I may, as attorney for appellant, if I could break my time up 11 and 4 for rebuttal.
that will be granted.
Okay, thank you, Your Honor.
You can begin whenever you're ready.
Appreciate it.
Yeah.
My approach.
Right.
Thank you, Judge. May it please the court. Good afternoon, Your Honors. Mark Epstein on behalf of the appellants Spencer. This case involves 3 fundamental errors that we believe the trial court has committed that must be reversed. An erroneous summary judgment dismissing counterclaims by my client that still had material facts in dispute, insufficient evidence to support a finding of a zoning violation, and bias in the proceedings. As you'll recall from our statement of facts, Your Honors, the Spencers have operated an automotive restoration business at 761 Highway 40 in Douglas County since 1989. Property is located in an unincorporated area of Douglas County just outside the city limits and was previously zoned B2. In 1989, the county approved the Spencer site plan for an auto restoration business, and at that time, the notes reflect that there were 35 to 40 vehicles present on the property. In 1996, the Spencers had approximately 90 vehicles on the property, and Douglas County Administrator Craig Weinball wrote that the property still appears to be in substantial compliance.
90 vehicles among the same vehicles that are there now?
There have been a shift in vehicles. There may be some. I mean, it's been that long, but there may be a couple that were. If I understand your question, if I were to look at 1996 and I were to look at today, are some of those vehicles the same? I think the answer is yes.
Do you know how many?
I don't, Your Honor. I don't know how many of those. There are a few in the back that I think showed up in a photograph that came up at trial. That there are some vehicles that are probably still vehicles that have been there since 1996.
Let me ask this preliminary question. After the bench trial, the court granted a 6-month, an injunction to be enforced within 6 months, right?
I believe that's correct, Your Honor.
What's become of that?
Nothing, Your Honor. Nothing's been moved. We're just here on the appeal of the, understanding, we're kind of two parts to this, right? There was the summary judgment, which disposed of all of Spencer's counterclaims without providing him an opportunity to try any of his cases.
There was no supersedious bond.
I don't believe so, Judge.
The county hasn't tried to enforce the injunction.
No, Your Honor.
All right, go ahead.
So in 1996, we had about 90 vehicles on the property. County administrator came out, looked at everything, and wrote that we were in substantial compliance with the site plan. At that time, the Spencers also obtained a certificate from the Kansas Department of Transportation for salvage storage. From 1989 to 2020, for over 30 years, the county issued exactly no notices of violation, sent no notices, issued no tickets, and had full knowledge of the condition of the property. In 2020, the county adopted a new zoning regulation that changed the B2 district to what is now GB. Critically, the GB district does not permit salvage yards under any circumstance, including even with a CUP. The notice of this zoning change was deficient and misleading. The published notice said the city would, or the county would consider text amendments. That's what went out to the public, to the zoning regulations. However, in fact, it was a complete repeal and replacement of the entire zoning district. Spencer received no notice that his B2 district was being rezoned, and certainly no notice that the change would be a wholesale elimination of that zoning district. In 2022,
was the county required to notify everyone in that B2 zoning area that something was afoot and that they may change that zoning designation?
yes, absolutely. They are required. They believed they complied. Their argument is we put something on our Facebook page, we published a notice, and we sent out flyers. The problem with that, Your Honor, is when you say there's going to be a text amendment, and those are the county's words, to the zoning district, one might believe that there would be tweaks to the B2 zoning that you currently have. That's not what they did. Unbeknownst to us, what they did is they repealed all of B2 and inserted instead a GB district on my client's property. And again, the critical part of that is under B2, we could have had a salvage operation. Understand, I don't believe we do. And we'll get to that as part of the error in the part that got tried to the court.
Before you go, so are you complaining that there wasn't notice or that the notice given by the county was inadequate?
I think it's both, Judge. I don't think you can declare a text amendment notice of a zoning change. If you say you're going to do a text amendment to amend a zoning district, that is completely different than I'm eliminating your zoning district in its entirety, including of substance that you will never be allowed to do the use that we're going to later accuse you of doing ever again. So understand, had somebody brought to my client's attention that the county truly believed that what he'd been doing there for 30 years was a salvage operation, I understand nobody ever had accused him of having a salvage operation, ever in B2. But had he been accused of that or cited for that or ticketed for that, the remedy would have been go apply for a CUP, because you can have salvage yards in B2 with a CUP, but nobody ever told him he was one, and nobody ever told him he had to apply for one. So he never did. My argument is because that's not what we are, and the county knows that's not what we are. That's why they never said anything for 30 years. The problem now is the way they've rezoned the property, you can never have what they've now accused us of having. I think the timing is suspect. As you can see, what has happened is they changed the zoning first to eliminate a use.
Then after they eliminate the use for the first time in 30 years, they say, oh, by the way, that's the use you're making. And surprise, can't have that anymore. Goodbye. So we have a whole host of problems, not the least of which is failure to give proper notice, a rezoning that did not have all the proper hearings. We're not given an opportunity to respond to those notices of hearing or anything like that. So that's part of the declaratory judgment. One of the bigger issues that we have, obviously, is the summary judgment on the counterclaims. We had declaratory judgment counterclaim, obviously, declaring the 2020 ordinance was adopted unlawfully. And a declaratory judgment action is exactly the type of action that you would use to challenge that kind of a fundamentally deficient notice. Because again, this wasn't an amendment, it was a rezoning without notice. The ordinance furthermore deprived my client of a vested right. So with the prior zoning, we had a right to have a salvage operation if that's what we were. And again, we dispute that we are, but we could have had that with a CUP. The new ordinance deprives us of that right. I would argue that that is kind of a conspiracy to basically ban one person from operating this type of business in the county, because you have to have banned it, then declared that you are that so that you can run them out of business. Had somebody declared us a salvage operation first, it could have been remedied with a CUP. But what they did is they took away this type of use first, then said, I think you're that use. Surprise, you're out of business. We also have an equal protection claim, and the trial court dismissed that claim, saying it didn't think that the Spencers could prove all of its elements. The issue is that the county failed to meet its summary judgment burden because it was on the county to prove that based on the undisputed material facts, they could prevail on our claim as a matter of law. There were no facts presented by the county. What the county did was an impermissible burden shift to say, we've looked at this and we just don't think that Spencer's ever going to be able to prove their case. And that is a wholesale misapplication of the law to our set of facts. And at the motion to dismiss and summary judgment stage, the Spencers only had to state a claim. If all of the allegations are presumed to be true, have we stated a claim? They didn't have to prove their case, they just had to state one. And Spencers did allege facts sufficient to state a legal claim. He alleged that similarly situated property owners were treated differently, and material fact disputes precluded summary judgment. More ironically, Your Honors, is the district court was in such a hurry to get rid of these counterclaims without hearing any evidence that when we had the hearing on the issue of whether or not we had a zoning violation, the evidence presented by the county's own zoning enforcement officer was, oh yeah, there are at least 13 other operations identical to this one or worse in zoning districts that don't permit that, but we have never sued them. So imagine my surprise when I'm standing there arguing the zoning violation. Are you or are you not actually a salvage yard? I've already had my equal protection claim dismissed. My argument was they treat other other people that have outside storage differently. I'm the only one getting harassed in the county for doing what I'm doing. They threw that out without listening to me. Now we're at the trial on the zoning designation issue. And the county administrator or the county zoning enforcement guy says, oh yeah, there's probably 13 that I know of. And asked under, well, have you sued any of them? No, just you. So the evidence in front of the very district court that threw out my claim for equal protection had to sit and listen to live testimony for the zoning guy saying, yeah, you're the only one I treated this way.
Before you sit down, I had a very basic question about Mr. Spencer's or the Spencer's enterprise. I mean, is it a money-making operation or intended to be?
It's intended to be, yes, Your Honor. I mean, to be truthful, I think it's really Mr. Spencer's hobby. Let's put it that way.
The impression,
yeah,
is he's restoring what he considers to be vintage cars.
Mm-hmm. That's correct, and he builds race cars to the extent that that matters, but they're all vintage race cars. So he has a giant shop within which are parts that you would never be able to find on the open market. but they are extremely valuable and extremely rare, and they've all come from his acquisition of other cars. And the only way to rebuild certain cars is with those certain parts. So you might have to buy 4 of those old cars to have enough parts to restore one to its prior glory, if that makes
Not
sense.
selling off the restored cars.
No, they're still all in that giant shed. He builds them, restores them, and he really doesn't sell anything, nor does he sell his parts.
Going back to my original question, I mean, of the vehicles that are stored on the lot, I mean, apparently some of them have come and gone and been replaced by others.
Correct.
Do you know what that process is? I mean, is he selling them off, or does he haul them someplace else, or how does that happen?
That's my understanding. Once the parts have been, and again, they're not harvested, they're not salvaged, they're not secondhand. He owns all of the vehicles, but he might have to acquire more than one of a type of vehicle in order to put one complete vehicle together. My understanding is once those have been reassembled in the shop, he basically keeps the restored perfect vehicle, and you can go out there and see the shop. He's got a dozen perfect cars, but then whatever is left is hauled off. I don't think he sells anything. There's no consumer. Nobody comes to the property to buy parts or buy shells. They're hauled off and discarded if they're of no value. If they can't be used in the restoration business, they're discarded. The front half is all moving vehicles. They're not being torn apart or restored or salvaged or any of those things. They all have plates, they all have tags, and they're still all movable. There are some in the back that are not. I hope that answers the question. I want to make sure I got you the answer, not my answer.
Okay, you're going into your rebuttal time.
Okay, then I'll let that go. I'll let the county go, and then I'll make sure I've reserved my 4 minutes, if that's okay, Your Honors. Thank you, Judge.
Good afternoon. May it please the court, counsel. With respect to Douglas County, the Spencer's appeal touches on 2 different stages of this case. One of those stages was the summary judgment stage, and then the second stage was the bench trial. If we start with the summary judgment stage, there were 2 key developments that I think really impacted the court's decision at summary judgment. That first development was that the Spencers basically changed the characterization of their use of the property. Up prior to summary judgment, they were fairly adamant that they were a salvage storage operation and that they were an antique salvage yard. And they justified their use of the property as being a lawful non-conforming use, and that they had a particular certificate from KDOT that they believed would allow them to conduct a salvage storage and salvage yard. When we get to summary judgment, that use changes, and it changes fairly significantly. And it seemed to be a decision that was strategic in that it potentially allowed them to offer an argument that could be used at the bench trial in a way to stave off the zoning enforcement claims. And the change is that they were no longer a salvage yard or a salvage storage operation. They were an automobile restoration business with unlimited vehicle storage under their site plan. And that change is significant because their counterclaims were generally either pertaining to or predicated upon a salvage yard, whether it was their claims for declaratory relief, whether it was their challenges to the zoning ordinances that dealt with salvage yards, whether it was their civil rights claims. They were all founded, at least in parts, on this idea that they are a salvage yard. Their ability to be a salvage yard with a CUP was taken away. The way that they've been treated as it relates to other salvage yards was an equal protection violation. But then when they get to summary judgment, they're saying we're not salvage yards anymore. We are an automobile restoration business, and we have unlimited vehicle storage. And that really did impact the court's decision as how those counterclaims could be dealt with on summary judgment. I think the second development that we saw at summary judgment is the Spencers firmly believe that they had no duty or obligation when it came to summary judgment. They believed that it was incumbent upon Douglas County as the party moving for summary judgment to conclusively disprove the Spencer's counterclaims. That it wasn't enough for the county to raise an issue or to notify the court that the Spencers did not have evidence to support all of the elements of their claims. It was upon the county to actually disprove, basically prove a negative. And so that led them to basically rely upon their prior allegations, the way they pled their claims, and a lot of conjecture, supposition, but not really coming forward with facts that would establish those counterclaims. And so those were two developments that I think were pretty key for the court when the court looked at the summary judgment. The second stage was the bench trial. And there was a key moment in the bench trial because one of the biggest issues that the Spencers had, and one of their biggest arguments was, is we are a automobile restoration business with unlimited vehicle storage under our site plan. And what came out during the course of the trial is that there was this site plan that was essentially modified in 1996 when Mr. Spencer applied for his certificate through KDOT. That site plan had certain labels added to it that were handwritten. One of those labels was storage area, and it clearly identified the storage area as south of this machine shed, which would have been screened by a machine shed to the north and then some fencing to the south. And then there were some other screening on the east and the west side. That handwritten label of the storage area was put on there by Mr. Spencer, and he acknowledged and testified at trial that that was his handwriting. So in 1996, he clearly knew what his storage area was. His storage area was limited south of that machine shed. When the court then went through at the bench trial, and the court did a very thorough and thoughtful approach to whether or not this property's use satisfied the definition of a salvage yard. The court also went through in quite a bit of detail to determine what did the site plan require, what storage limits, if any, were imposed under the site plan. And the court laid all that out and ultimately determined that the salvage yard, or that this property was in fact a salvage yard, and that it was operating in violations of the storage for the site plan. And as a result, the court did enter a permanent injunction enjoining essentially the use of the property as a salvage yard and requiring them to get back into compliance with their site plan.
Was there in fact testimony at the bench trial from county agents or employees that there were 13 other similar storage facilities in the unincorporated area of Douglas County?
Yes, there were.
And that they were not being sued?
That's not quite correct. There was testimony from the codes enforcement officer that the county was aware of 13 potential salvage storage operations in the unincorporated area of Douglas County. There was also testimony that 3 of those were actually dealing with enforcement. One of the 13 was the Spencers. 2 of the others were being dealt with the county. But the difference is those individuals were working with the county to obtain voluntary compliance. So they were actively working with the county to get those vehicles off their property and to get their property back in compliance with the code. So while it would be probably more proper to say that the county was aware at that time of 10 other instances that had not been dealing with enforcement as of that date.
Does that have any bearing on the protection claim?
I don't believe so, because this was a class of 1 equal protection claim. And in this particular case, I believe the law would require that they would show that there were others that were similarly situated to them in all material respects. And that's a pretty, high standard. And they didn't come close to meeting that standard. Partly because what they were claiming by the time you got to trial is we're not a salvage yard. We're an automobile restoration business, and this is a vehicle storage issue under our site plan. That puts comparators outside of salvage yards then. If that's their argument on equal protection, is that we are a automobile restoration business with unlimited with unlimited vehicle storage, then the comparators that we would be looking at is, are there any other automobile restoration businesses that are violating the conditions of their site plan as it relates to vehicle storage? And how are they being treated? Are they being treated differently? That wasn't evidence that was brought before the court.
Counties consider salvage yard.
Correct.
Well, again, I mean, does that impact the equal protection claim? And the county is saying they're a salvage yard and it's admitting there are 10 other salvage yards that aren't being pursued in litigation.
I don't think it impacts the claim in that there would still be examples of the county enforcing its zoning regulations against salvage yards. It may not have been doing it at that point in time against every known salvage yard, but it was working through at least 3 of them. And so there was at least evidence that the dispensers weren't being like treated completely different than all other salvage yards. There were at least 2 that were dealing with zoning enforcement issues at the same time. The difference in their treatment has always been that the dispensers have not been interested in working with the county to obtain voluntary compliance and to address these issues. They've always felt very strongly that they were not in violation of the code, and they wanted to have their day in court, which, you know, they were obviously entitled to. Are there any other questions?
Apparently not.
Well, the request from the county is we believe that the court properly dealt with the counterclaims at summary judgment, and the court properly found that there was a salvage yards use that was unlawful in the GB zoning district, and that the dispensers were operating in violation of their site plan, and we're just asking the court to affirm those decisions.
Good afternoon. May it please the court, Todd Thompson for Gary Ziegler, the third-party defendant. We obtained summary judgment for Mr. Ziegler for a couple of reasons, but I want to reiterate what Mr. Heineman said, and that is that the plaintiff or the defendant decided to just rely upon an improper understanding of the duty in a motion for summary judgment. The reality is, and it was repeated just a minute ago, when Spencer's counsel said, we just have to state a claim. Well, that's not correct. That is not their duty. In this instance, there are 5 elements of a conspiracy claim, and that's the only count that Mr. Ziegler was involved in. If the proof is there that they can never meet one of those elements, any one of those elements, then we were entitled to summary judgment. And that's exactly what happened here. They were not able to show, and really didn't even attempt to show, that they could meet all 5 of those elements. I want to refer to the Celotex case, a U.S. Supreme Court case that says, it was quoted in Goff, a Kansas case, defendants again essentially assert that the movement was required to set forth a statement of uncontroverted fact asserting there was no evidence of the particular issue. That's not the test. They actually have a duty under Celotex and numerous Kansas decisions to come forward with facts to show that they can present a prima facie case meeting all the elements of the claim. If one element is not shown to be viable, then we were entitled to summary judgment, and that's what we requested and received. Is the clock still set on his main time? This is my 3 minutes. Okay. Then I'll just skip to the end and say the court did exactly what it was required to do. The purpose of summary judgment is not some evil thing. It's a proper procedure to get rid of factually unsubstantiated claims. That's what the court found here. Plaintiff didn't, or the Spencers didn't even try to come forward with enough facts to support their conspiracy claim, and the decision granting summary judgment should be affirmed. Any questions? Thank you.
Counsel, you still have your rebuttal?
I appreciate that time. The county has attempted to put the Spencers in a box by accusing them of being a salvage yard and then not allowing them to argue that if they are, they're being treated differently than other salvage yards. And this is the part of the conspiracy that we have alleged all along. Nobody's ever accused us of being a salvage yard in the last 30 years. It wasn't until the county took it upon itself to ban salvage yards under GB that they then decided that we're a salvage yard, so we can never operate ever again. Had they ever brought this up before, the Spencers could have gotten a CUP and been allowed to continue. So you can see the timing and the tactics the county used to try to run the Spencers out of business at the Ziegler's request. The fact that there's the argument that there's no evidence of a conspiracy is absolutely false. The emails between Tanya Voigt and Mr. Ziegler were pretty clear that she had invited him over to her house, that she was taking it upon herself to start writing violations as though there had never been one in 30 years, that she even went beyond that and started calling the health department, the sanitation department, KDOT, anybody she could talk to see if there was some way to violate the Spencers. The issue is we've always held ourselves out to be an auto restoration business. That's what's on the site plan. That was even what was on the application for the KDOT salvage storage certificate. It doesn't make you a salvage yard, it just means you can have storage. The county then wants to conflate parking with storage, right? There's an area on the site plan from 1989 that talks about parking. Well, that would be for customers. That's not the storage area. Those are two separate things. There wasn't a limit on the storage for vehicles being restored. We're not a salvage yard, but when they called us one, we had no choice but to say, okay, if that's what we are, right? We've got cars parked outside. That doesn't automatically make you salvage. There's a whole definition of it. And again, Tanya Voigt under cross-examination during the trial said, I never did see any vermin. I never really did see any leaking fluids. I never really didn't see anybody coming out and taking parts, secondhand, buying and selling scrap. None of that ever came out. So we're not a salvage yard. We're just not, right? But that's what they called us. So our argument is, okay, well, if that's what we do, if just simply having a bunch of cars in the yard is a salvage operation, how about these 13 others? Oh, yeah, well, yeah, we know all about them. We're just not doing anything. And to argue that, well, they're a little bit different, absolutely patently untrue, or the argument that we somehow didn't prove it, also untrue. There was, I don't know, 80 pages of zoning maps and aerial photographs showing all of the other people similarly situated to us. And I don't care what you call it, they're doing what we're doing. They are storing vehicles outside in an area not zoned for outside storage. So I don't care if you call it salvage storage. I don't care if you call it an automotive restoration business. They're doing the same thing. But none of them got sued. What Mr. Hyman said is two of them worked with them. Well, they gave them a stay of execution of 5 years. Can you just get the stuff off? One guy said, sure. Nobody's been sued. We're always being treated disparately than others that are exactly in the same situation. There was no violation of the site plan. We've simply been zoned out of existence. We were all treated the same. The zoning maps and the photographs showed that we're the same. We're just not being treated the same. And understand, Your Honors, and I know you know this, but here's my understanding. I'm not asking you to say I'm right? What I'm asking you to do is reverse the court's decision that we lose on summary judgment. Essentially, what we're saying is we did present enough facts to support a claim for declaratory judgment for equal protection for the conspiracy, right? And we lost on summary judgment. So your reversal of the trial court's decision, because there were disputed facts, there's a whole host of issues. We were clearly denied our due process on the zoning issue. Not asking you to find that we were denied our due process or that we're not a salvage yard. What I'm asking you to do is give my client his day in court. That's what the reversal does. It doesn't say the judge is wrong and that we aren't those things or that we have somehow been deprived, but reverse the summary judgment and require the district court to let us present our case. Give my client his day in court, and then let's make a decision of whether or not those are right. But the denial on a summary judgment with facts in dispute And worse yet, to have a trial where the county's own witnesses prove part of my element that was already thrown out requires a reversal. So we respectfully request that the summary judgments on our counterclaims be reversed and that the court also reverse the finding that we are a salvage yard and send this back and give my client an opportunity to get those in front of a jury. Appreciate all of your time this afternoon.
Thank you, Ken.
I'm sorry, Your Honor, did you have a question, Judge Malone?
No.
Okay. Thank you, gentlemen.
All right, counsel, thank you for your briefs and your arguments. We'll get an opinion out to you as soon as we can.
Thank you.
Final case is Leavenworth County, 128-948, Whiskey Ridge LLC et al. Versus Leavenworth County Commission and Mike Steben. Who do we have here for the appellant?
Good afternoon, Your Honor. Steve Maurer and my partner Jamie Walker here on behalf of appellants Whiskey Ridge, Orson, Dan and Cindy Lynch, and also present in the courtroom are Mr. and Mrs. Lynch.
And for the appellee?
Good afternoon, Your Honor. Alex Gilmore for the Leavenworth County Board of County Commissioners.
Brady Sullivan on behalf of defendant and appellee Mike Steben.
And are you both going to be arguing?
Yes, Your Honor. We've worked out time limitations, but I'll take the first 10 minutes and Brady will take the remainder.
Okay. So we'll start with the appellant. And do you wish to reserve any time for rebuttal?
Yes, Your Honor. May I have 12 and 3, please?
And that is granted.
Thank you.
Whenever you're ready.
May it please the court. My name is Steve Maurer, along with my partner, Ms. Jamie Walker. We represent appellants Whiskey Ridge, Orson, and Dan and Cindy Lynch. Mr. and Mrs. Lynch are also here in the courtroom. This matter arises out of my client's attempt to operate their business, a wedding and event center in Leavenworth County. I know the court's familiar with the facts, so I'm going to dispatch of a long discussion of the facts, and I'm going to get right to the issue that is the principal issue for this court's consideration. And I think it's probably unique in the court's experience because it's not often that this court might hear a case where it is absolutely undisputed the court below made an error. It is undeniable and agreed to by all parties that the court below, the district court, was wrong in its application of Kansas law. In this instance, the court.
Standard of review.
Yes, Your Honor.
Following the federal.
Yes, Your Honor.
What remedy?
I'm sorry?
What is the remedy for that?
The remedy is, well, we believe the remedy is to consider the case improperly decided, and we should be remanded back to the district court, and we should be able to go forward to conduct our discovery, to establish our case, and have our opportunity to present our arguments to the court. Defendants will argue, well, yes, there's an error, but since your scope of review is de novo, you can go ahead and apply the Kansas statute correctly and still find in our favor.
Why is that not a proper remedy? That seems to me as an appellate judge, the most efficient thing to do. I mean, again, the standard of review is bad. I agree with that. And you're entitled to a much more favorable standard of review, but it is a de novo review on essentially undisputed facts. Why can't we just go ahead and do that? Or shouldn't we do that?
Well, you certainly can, Your Honor, but if you apply the proper Kansas standard of review, which is if the petition has any factual allegations which could state any claim under any theory, whether it's a theory that we articulated or not, then the case gets to go forward. And if you utilize that standard, then under the undisputed pleadings, then the case has to be remanded and we get to go forward. The only thing that the district court pointed to and relied upon in making its decision to dismiss our case was other extraneous evidence presented by the defendants in support of their motions to dismiss. And unlike what's required by Kansas procedure 6212D, when a motion to dismiss relies upon and attaches extraneous additional evidence beyond the petition, then the court is to treat it as one for summary judgment and give the plaintiff an opportunity to present its own material evidence. Unlike the argument you just heard, where there was a bench trial, discovery, and then summary judgment, my clients were deprived anything. They were not given an opportunity to conduct any discovery. They were not given the opportunity to ferret out and develop the facts behind all of the facts behind their claims. We were from the very beginning confronted with the county's and the defendant's self-serving documents, which were not even authenticated, and then said, well, see, based on our own documents, plaintiffs lose, grant us, dismiss their case, which the district court did. The district court did not give us discovery, did not give us the opportunity to rebut those documents, did not give us the ability to present, to develop, discover, and present our own evidence.
Question about the tortious interference.
Yes, sir.
And I assume we're dealing with essentially the second amended petition here.
That is what the district court did, yes.
Well, and you're not claiming that was error, are you?
Yes, I would, Your Honor, in that the First Amendment petition undeniably cured any procedural issue, and we should have been able to go forward on the First Amendment petition. We should have never been required to file an incredibly detailed Second Amendment petition because our First Amendment petition in and of itself was more than adequate.
Well, the question I have goes to what the agreement was that was interfered with. And as I read the second amended petition, at least, the agreement is one essentially from David Van Paris as senior legal counsel, that if certain things happened, Whiskey Ridge would be granted a use permit without the sprinkler system or the fire retardant requirements. Is that correct?
In part, Your Honor, yes.
What's the other part?
The other part is, as we alleged, we specifically alleged that the county commissioners knew of and approved Mr. Van Paris's representation to my clients that if you go get this waiver from the state fire marshal, you will be granted the SUP so you don't have to put in the sprinkler system. My clients did not know about the state fire marshal and the ability to go get a variance. The county directed them to do that. The county directed them to go get an engineer to give you a full scope review of the fire safety of your building, and we will accept that along with the variance. That was a promise communicated by Mr. Van Paris as attorney for the district, but it was authorized and approved by the commissioners.
The evidence of that, I mean, or even the allegations. I mean, I'm not sure I saw the allegations that it was approved by the
in paragraph of the second amendment petition, I believe it was paragraphs 58 and 59, we alleged that it was a binding agreement and to be binding, according to the defendants, it has to have been approved and authorized by the commission. So I think a fair inference is that. And then I also believe on page 25, I think it's paragraph 185 and 186, we specifically allege that the commissioners knew of their contract that if we got the variance, we would be given the SUP. And so we did allege that it was approved and with knowledge and authorized by the commission. And that is in there. If the defendants want to argue that Mr. Van Paris stepped out and didn't have authority, I guess they can take that position, but then they walk right into a claim of fraud or false or negligent misrepresentation, because my clients certainly relied upon it. and they certainly have damage, and they have every reason to believe that they could rely upon that representation. And so there still would be a claim that could be brought based upon the facts as we've alleged in the petition.
Did Mr. Van Paris, as you understand, his role have the authority to bind the county?
Absolutely. An attorney absolutely has the ability to make representations and bind their client. That is a strong principle of Kansas law, every state law that I'm aware of. And so, yes, Mr. Van Paris would have the authority. And as we pled, he communicated that to our client with the knowledge and approval of the county commission. The defendants and the district court tried to recast our tortious interference claim to say that we had an agreement with Mr. Van Paris and the director of planning and zoning, Mr. John Jacobson. We never alleged that there was a personal agreement with Mr. Van Paris or Mr. Jacobson. We alleged it was an agreement with the county, communicated by them. And so that is absolutely the basis, or one basis, of our tortious interference. And what matters, Your Honor, about that is, as we've pled, we got the variance. The state fire marshal gave it to us. And then, in an incredibly unusual, atypical behavior, defendant Steben called the state fire marshal and told the state fire marshal, hey, why did you do that? We've passed zoning and we want all businesses, all construction to comply with the new building code throughout Leavenworth County. And we know that that's not true. We know that Leavenworth County exempted 1/5 of the entire county from the new building code. It only applies to 8 of 10 townships. We also know, as we've alleged, that we're the only ones that have been required to put in a sprinkler system. Every new construction in the county, nobody's had to do it except us, as we've pled. And it was so bad by Mr. Steben that, as we pled, when he was confronted about making the phone call, he lied about it. He denied it and said, I didn't make any phone call. It was only after he was pressed and pressed and pressed that he finally admitted that he had done it. Which begs the question, Your Honor, if the variance was no big deal, if the variance didn't matter, if the variance wasn't part of the agreement, why to go to all the trouble to have the state fire marshal rescind it? And why lie about it? Of course it was important. Of course it was what my clients were told and promised and agreed to. And by the conduct of Commissioner Steben, he tortiously interfered with it, as we've alleged, outside the scope of his authority, outside there was a commission of any commission meeting. He did it to politically retaliate against my client, Mr. Dan Lynch, because Mr. Lynch refused to provide political or financial support to Commissioner Steben. And because of that, he retaliated against my client. And we have pled those claims. The district court completely brushed aside and ignored our claims of misconduct, ignored all our evidence and our allegations, of disparate treatment towards Mr. Lynch and my clients. In fact, our Second Amendment petition lists off 5 different examples of things the county has done just to retaliate against Mr. Lynch. And the district court in passing says, well, now the plaintiff says there's a pattern, but the plaintiff should have recognized the pattern at the time of Whiskey Ridge. Nowhere in our petition did we plead that those things occurred before Whiskey Ridge. We've alleged that those are incidences of retaliation against Mr. Lynch. The district court just bent over backwards to find a way to dismiss our claim and deprive us of our day in court or any discovery or an opportunity to even challenge the evidence put forth by the defendants, which included an unauthenticated YouTube video and documents from non-parties which were not accompanied with an affidavit. They wouldn't even satisfy the requirements for summary judgment to be admitted evidence, let alone on a motion to dismiss. I see my time is up. I'll reserve the rest for rebuttal unless the court has any questions. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Alex Gilmore, and I represent the Leavenworth County Board of County Commissioners. District court properly dismissed this case on two independent bases. We heard a lot of discussion today on whether or not plaintiff's second amended petition failed to state a claim. A plaintiff's position is obvious that they plead enough under Kansas notice pleading statutes. What we haven't heard today is any discussion on whether or not the district court properly found that it lacks subject matter jurisdiction. I would like to focus the court's attention this afternoon on that prerequisite. Kansas district courts have limited jurisdiction over the administrative decisions of quasi-judicial boards, including a board of county commissioners, zoning and planning decisions. That is statutory-based jurisdiction. There's two relevant statutes that I'd point the court to in this appeal. It's KSA 12-760, which deals with planning and zoning decisions by the Board of County Commissioners. That statute mandates that any aggrieved person who wishes to contest a final decision by a Board of County Commissioners has 30 days to file an appeal.
But as I read the second amended complaint, and it's this isn't contesting the zoning decision. It's seeking monetary damages for torts and constitutional wrong. Why does the exhaustion doctrine even apply here?
Yeah, that's a good point, Your Honor. And I think
I make good points every now and then.
And here's the answer. Kansas courts have consistently held that you can't collaterally attack decisions by a Board of County Commissioners on an independent cause of action claim, right? That's exactly what the plaintiffs are doing in this case.
It's not. They're not asking to have it set aside and they don't need a sprinkler system anymore. I mean, they're living with the zoning decision. They're seeking money damages for things that occurred along the way.
They are contesting the actions taken by the board and the Board of Building Code Appeals throughout the special use permit process, including alleging a takings claim that SUP 1 was taken without just compensation, that there was a substantive due process violation committed by the board because they deprived a property right from the plaintiffs as a result of these board decisions as it relates to their special use permit. So it is a collateral attack. They're sidestepping the jurisdictional appeal issue and they're doing it quite cleverly, but there's case law in Kansas that says you can't do that.
We've required to exhaust as to their constitutional claims.
Yes, Smith, State XRL Smith v. Miller, that's a tax valuation appeal. In that case, plaintiff didn't file an appeal through the process established by the challenging the tax valuations. Instead, he filed a petition later on, including claiming that the issues were unconstitutional. So that case is directly on point as it relates to an independent cause of action. Yeah, State XRL Smith v. Miller, 1986, Kansas Supreme Court.
I mean, with the constitutional claims, we would look at federal law and exhaustion. Isn't federal law fairly clear that you do not have to exhaust state administrative remedies to bring a 1983 action?
I think it depends on the claim, and I can't give you a clear answer on what the federal courts say. I can tell you that when Kansas courts are dealing with zoning challenges, which is what the defendants contend is occurring here, including independent causes of action, is that you do have to exhaust those administrative remedies first. And if you want to collaterally attack, like bring a constitutional claim, for instance, you would do that at the district court.
They aren't collaterally attacking it. They're asking for money damage. They aren't asking that the zoning be changed.
They're challenging the board's decisions affecting their special use permit, Your Honor. And by doing that, they're just alleging a different cause of action. They're not saying reverse or otherwise set aside the planning, the board's decisions with respect to planning and zoning, but they're saying that those decisions violated their constitutional rights. That's a collateral attack of the board's decision.
For which they're seeking money damage.
Correct. But they still have to exhaust their administrative remedies first. If they had done so, then we wouldn't be here talking today about money damages and constitutional and tortious interference claims. If they would have appealed those underlying decisions, then the remedy was for the district court to send it back to the board for reconsideration. We wouldn't be here talking about whether or not a constitutional violation was adequately pled, because they would have exhausted their administrative remedies and had a remedy for the complaints that they now seek for you to reverse. Any more questions? Okay. I think that the record is clear based on the allegations of the second amended petition. I'm not asking the court to review the extraneous materials because the well-pleaded facts established that they didn't exhaust their administrative remedies. Regardless, I think this is a subject matter jurisdiction case. Kansas case law is clear that this court can consider extraneous materials when deciding whether or not the district court had subject matter jurisdiction. There's no requirement that we convert this into a motion for summary judgment, consider contrary evidence that the materials are, they're governmental materials, not subject to dispute. The plaintiffs have never genuinely disputed the authenticity. They're just saying, well, you didn't put an affidavit together, so therefore the district court improperly considered these. So I think that the case law is clear that the district court had the right to consider these on a subject matter jurisdiction dispute. And I think what's important to underscore to the court is that it's not a merit-based argument. It's the documents simply pinpoint the structure of events, the sequence of events that occurred as to why we ended up here, and not the sequence that I think that the case law and the statutes require. Is that on 3 separate occasions, the plaintiffs had an opportunity to appeal decisions that they didn't like. They chose not to do that and continued to tread along. The Board of Building Code Appeals denied their request for a variance. Pursuant to county regulations, they had a right to appeal that decision under KSA 19-223. They didn't do that. Instead, they proceeded to submit a request for a special use permit without a fire suppression system. That was denied. Again, they had a right to appeal that decision. Instead, they went ahead and installed a fire suppression system and applied again for a new special use permit. The board ultimately granted them a special use permit after they installed their fire suppression system, and they put that as a condition to approval of their special use permit. Again, they had a right to challenge that, and they never did so. Instead, they waited a year, filed this claim. And I think we've cited ample case law in our brief and in Defendant Stevens' brief as to why that's not presented under Kansas precedent. I'll reserve the remainder of time for Mr. Sullivan. Thank you.
Your honors, may it please the court, Braden Sullivan on behalf of appellee Mike Steven. I'd like to try to quickly cover 4 topics. Why the failure to exhaust applies to the tort claims too, why the tort claims fail independently, separate and apart from that analysis, why the failure to use the correct standard of review constitutes harmless error, and why it was not error for the lower court to consider materials outside the pleadings. As my co-counsel explained, the appellants had at least 3 opportunities to appeal the county's decisions and failed each time to do so within the time frame required by KSA 12-760. They now attempt to repackage these complaints as tort claims in an effort to circumvent the requirement to exhaust those administrative remedies within that time frame. However, we have ample case law cited in our briefs showing that that is not allowed under Kansas law. KSA 12-760 applies to any person aggrieved by the decision of a city or county. And this whole case, no matter how it is packaged, clearly boils down to the fact that the appellants are aggrieved by the county's decision to require compliance with the 2006 International Building Code.
Isn't what they're pleading, they're aggrieved by what your client did going to the fire marshal.
That is the underlying conduct, but our position is that is a part of the decision-making process as in relation to this SUP and these variances, all a part of, well within the purview of the county, whether through the Board of County Commissioners or the Board of Building Code Appeals. Our briefing outlines that this is well within Stevens' authority to do that as a valid ex parte communication. There's a case to that point, McPherson, in the briefing that I would refer you to for that point.
Well, that's the argument that it's not wrongful. I mean, that doesn't have anything to do with a collateral attack on the zoning variance or the use permit.
No, I think you're right, Your Honor, but there's 3 cases we cite to in our briefing to the effect or stating the legal point that you cannot circumvent the requirement to exhaust administrative remedies by bringing other claims outside of the to bring other claims outside of that context. Those cases would be Johnson County Memorial Gardens v. City of Overland Park, State X. Rel. Smith v. Miller, and Sandlin v. Roach Labs. Each of those cases, there was a city or county decision with a clearly outlined administrative appeal process that was skirted around by bringing other claims.
They have brought a declaratory judgment action now saying that the variance was improperly granted and they were improperly required to install a sprinkler system. But that's not the claim they're making.
The underlying conduct and the underlying damages all arise from the same decision made by the county. And again, Stephen's conduct, the phone call that they complained of, is a part of that decision. In fact, the decision was made to require compliance with the 2006 International Building Code. And this phone call was an continuation of that decision to make sure that the fire marshal was made aware of the county's adoption of the more stringent code, which he himself then realized he didn't have authority to grant a variance to because of the county's more stringent code. Did I answer your question, Your Honor?
Well, you've given me an answer. I'm not sure I'm persuaded, but go on.
Again, there's language in each of those three cases I cited to stating that you're not free to pick and choose your avenue for the same underlying conduct or decision of the county. You must follow the appeal process outlined in KSA 12760. And no matter which way you slice it, they are a party aggrieved by the county's decision. And that triggers their requirement to exhaust their administrative remedies, which they failed to do. I'll quickly also explain that independent from that, their claims for tortious interference fail for various reasons. Under the latest theory pled in their second amended petition, which references the contractual agreement between Whiskey Ridge and the individual county staff members. The individual county staff members do not have the authority to bind the county as a whole. I acknowledge their position that the county adopted this position, but their pleadings make clear that this was communicated directly from the county counselor himself and was not from the board as a whole. And individual county staff members do not have the authority to bind the county as a whole. Only the Board of County Commissioners can grant an SUP, and only the Board of Building Code Appeals can grant a variance. And any contract entered into by individual county staff members is unenforceable as ultra-virus under the ultra-virus doctrine and cannot form a basis for a tortious interference claim. And quickly, I'll just conclude by reiterating that the court's failure to use the correct standard of review constitute harmless error. One, even on the face of the pleadings, accepting all of their allegations as true, it's still clear that this arises out of their disdain with the courts or with the county's decision on the to require compliance, and thus they needed to exhaust their administrative remedies and they failed to do so. And also it's clear from the face of the pleadings, there was no valid contract or reasonable business expectancy that could form the basis of a tortious interference claim. Thank you, Your Honors.
May it please the court. I'd like to address your issue of what is our claim. Our claim is for money. We are not suing so that we don't have to install the sprinkler system as we've pled. We already did it. It's in. The problem for the defendants is that after they did it to us, we found out, oh, wait a minute, that's not really the standard. They haven't made anybody put in a sprinkler system. And there was more conduct by them where they are retaliating against Mr. Lynch and his businesses for political reasons. All of those things form our claims for tortious interference. They form our claims against the three commissioners, Katz, Culberson, and Steben. We've alleged they got together. They conspired to retaliate against Mr. Lynch for political reasons. Those form a claim that we're entitled to go forward and present and gather evidence and present. What has happened in this case, all you heard about was the exhaustion of remedies. You asked me in the beginning about my first amended petition. Your Honor, the whole exhaustion of remedies only arises from their motion to dismiss and all of the extraneous documents. The exhaustion of remedies begins with their claim that we should have appealed the decision of the BOBCA, Board of Building and Codes Appeals. There was nothing in my petition or First Amendment petition that even mentions the BOBCA. What has happened is they've recharacterized our claim as one for zoning and then introduced the BOBCA supposed decision and then said, aha, you didn't appeal that, so you're out. Even though—
Before your time is up, let me ask a couple of questions. Quickly give me 2 sentences of what your substantive due process claim is, apart from the equal protection claim. What's the substantive due process violation?
Substantive due process is that we were required to comply with a statute that no one else has been required to comply with, and we were not given proper notice as the county is attempted to dodge because we've pled, we did not get notice of the withdrawal of the SUP. We did not get notice of the decision that we have to appeal the BOBCA. In fact, the evidence that we've pled.
So it has to do with notice about the decision making.
Notice about the ramifications of the decision making. Yes, Your Honor.
Now, the other question I had from looking at the briefing, I didn't see a separate argument about the Kansas takings claim. Have you essentially dropped that?
No, Your Honor. We did include it in our briefing, I believe. The taking is that we had an SUP that was voted on and approved by everyone. COVID put it in hiatus. The county.
No, I mean, I understand that argument. I just didn't see anything in your appellate brief addressing that.
I'll have to look, Your Honor. I don't recall it off the top of my head, but no, we have not intentionally abandoned the takings claim.
All right.
I see my time is up. May I have one moment to conclude?
Yes.
Thank you. Your Honors, for all the reasons stated and for all the reasons set forth in our briefs, we respectfully request that this court reverse the district court, remand with directions to go forward to allow my clients to develop their case and ferret out all of their causes of action. Thank you.
All right, counsel, thank you all very much for your briefs and your arguments. We will take the case under advisement, get something out to you just as soon as we can.
Thank you, Your Honor.
And with that, today's court hearings are adjourned.